and Christopher Thomas Jr. Now, the two victims, who went by stage names YNW Sack Chaser and YNW Juvie, they were on their way back from a recording session with the Murder on My Mind rapper and his co-defendant, Cortland Henry, on the day in question. Now, Demmons and Henry claim that October 2018 incident was a drive-by shooting. But authorities later found evidence to suggest that the shooting actually took place from inside the vehicle. Now, last week we heard from a slew of witnesses, including a DNA analyst and an undercover detective. And I actually want to start with that undercover detective while we wait for court to resume this morning, because this is the testimony of Detective Danny Polo with the Broward County Sheriff's Office. And you will notice that we are not showing his face as to protect his identity. Check it out.
So you talked about doing gang investigations. What does a gang investigation entail?
You initially start, a lot of times you start by, you get complaints from the neighborhood, or whatever neighborhood is being affected by gang violence, or just you observe shootings that are happening in a certain area, and you start looking into it to see if it's random or if there's something more organized going on. A lot of times we find that these violent crimes are being committed by members of criminal gangs. And once we've identified the criminal gang, the main goal is to identify which criminal gang it is. That way we know how to approach it. Some gangs are more structured than others. Some are very informal and don't have much structure at all.
So Detective Polo, if we could just go on a little bit on that, as the types of criminal gangs.
Sure.
Can you define for the ladies and gentlemen of the jury what would be a national organized criminal gang?
So the national, they're called national gangs because they're found in multiple states. Doesn't mean every single state will have every single one of these gangs. So like most people see on TV, Bloods, Crips, Gangster Disciples, the Mafia, biker gangs, motorcycle gangs. These are national gangs. They have chapters, sets, they call them sets, or lineups, in multiple states, multiple jurisdictions, all over the country.
Polo, you also mentioned that sometimes they're a little less organized. Could you explain what a neighborhood street gang or hybrid gang is?
Neighborhood street gang is just that. When you have a neighborhood that hasn't you have a group of 3 or more individuals involved in criminal activity, ongoing criminal activity, and they decide to take on common hand signs, colors, symbols, clothing, anything to unify them and show that they are a group. And they operate sometimes within a city, or they can operate within multiple jurisdictions, but they're working together and they've adopted these common identifiers. These gangs sometimes eventually will report to or turn into national gangs, but for the most part, there's many neighborhood street gangs. You can have one neighborhood, one 10 by 10, apologize, 10 by 10 blocks of a neighborhood where you have 5 different gangs operating within that neighborhood. They might get along, they might not get along.
Okay, so in terms of the amount of time or resources that you put into a gang investigation, how long does it take?
We work every case differently because some of these cases require years of investigation because the gang might be very, very structured, or just have a lot of financial support due to whatever crime they're committing, and those gangs are a little harder to tackle. So you have to invest a lot more time, a lot more money, a lot more resources into dismantling this type of organization.
Okay, so I'm joined right now by psychologist Dr. John Delatorre. He's joining me. Good morning, doctor. Thank you so much for coming on. I feel like I have a lot to talk to you about with this case, but I'm going to start right now with the gang part of this. So we're learning a lot what goes into gang investigations. We're figuring out how they're organized, what makes them a unit. I'm curious because we have to go back to the motive here in this case. The motive is, and at least that's what I can establish from the prosecution, that the defendant YNW Melly was part of the G-Shine Bloods, and maybe as a way to show his loyalty, he would have killed his 2 friends, What should we be thinking about in terms of gang mindset and gang culture?
I mean, it is certainly possible that that kind of request would be made. But the problem is that if they were all members of the same gang, you wouldn't necessarily want to get rid of members who would be earning for the gang. So other members who might be contributing through, selling drugs or whatever other organized criminal activity. So you don't necessarily want to do that. Typically, when we hear of these kinds of tasks being levied upon one of the gang members, it's usually because they've done something outside of the gang organization, that they're somehow being punished, that maybe they weren't as loyal. So in order to prove that loyalty, then they have to engage in a task that most people wouldn't actually want to be a part of, because we have to remember these gangs operate as pseudo families. Right, that these individuals feel compelled to be a part and spread the love that you would see in a family, but because they don't have it as a legitimate family, they find it through this organized crime structure. And so it would be an unusual task to levy against someone within the gang culture. Now, certainly possible outside the gang, but I don't know. It's a very curious task that was being asked upon him, if that was accurate.
Now, later on in his testimony, he discusses more of the details about gang rules and how to move up the ranks. I want to listen to some of that. Again, this is from Undercover Officer Detective Danny Polo.
Detective, you talked about how people are promoted through the ranks.
Yes.
Is that reflected in this document?
In this one page?
Yes.
No, it's just like the principles of the gang, specific things that meanings they gave to symbols that they have within the organization. So like the 5-point star, they give meaning to each point of that star. Pyramid, what the pyramid means. The crown, the 5-point crown.
Okay. Moving on to the titled 23 Rules. Was that this is, so it's clear for the record, the second attachment on this email?
Yes. These are all rules you'd be expected to abide by.
Number 12, communicate with someone on the lineup. Is that the term you defined earlier?
Tapping in, yeah. You need to make sure to report to your up your chain.
Okay. Moving on to the third attachment, what is this one called?
5 ways of banging up. This is how acts and ways that you can move up within the ranks, ways that you're expected to participate and do things for your organization, for the gang.
Okay. In terms of...
So, are we all ready to proceed, Council?
Yes, sir, we just have to have the witness run around.
Bennett, you ready to go?
Yes, sir. Good morning.
Good morning. Let's see if check on it.
I don't think it's cold enough in here, Judge.
When did you start?
Why should today be different than any other day?
Called them Friday, told them that you complained about it on Thursday. It was a little too warm in here for you. They said they were going to adjust it accordingly. I appreciate that.
It's the Easter egg for things.
There's no happy medium in life.
Could we approach off the record?
Sure, we've got a one screen.
were part of the G Shine Bloods, this offshoot of the Blood Gang. So again, it makes me curious if he was a part of it and they weren't, perhaps he killed them as a form of loyalty. That's what the allegation is being put forward by the prosecution. But doctor, I want to ask you something more about the witness, Detective Polo. We're not showing his face, but what the jury saw was him wearing essentially a robber mask, like a ski mask. You can only see his eyes. And that had an effect on at least one of the jury in general. They sent 2 notes. One juror was almost traumatized. It triggered her because it reminded her of a robbery that she had seen in the past or maybe was a part of. And then the other jurors were, or there was one note from one other juror that they were concerned that why can he see them and they can't see him? Now, I'm curious about what you make of the jurors' perception of Detective Danny Polo and if it's distracting them from what he's saying about the gang culture.
I do think it is a bit of a distraction. Now, I think that there might be some jurors who would be a little bit more sophisticated and understanding that infiltrating an organized crime family like a gang or anything like that, even one as disorganized as a neighborhood street gang, still requires a tremendous amount of effort by the police. But if you live in a community in which crime is rampant and these kinds of imagery is constantly being shown to you, right, it's automatically going to elicit all different kinds of negative emotions, and it's going to make you focus on those negative emotions rather than the material that is being testified to. So yeah, it's a double-edged sword where you want to protect the officer's identity, but you also got to understand that by doing what you did, by putting him in a mask like that kind of mask, I'm sure there were other ways that you could have protected his identity. By doing that, it was automatically going to elicit certain kinds of emotions that may be too distracting for jury members to actually manage at that time.
And let me ask you this, the mere mention of the term gang and the fact that the prosecution is putting this in there, does that bias a jury? Do you think there's such negative connotations with the gang culture that that might influence them improperly and not weigh this the way that they should and automatically say that the YNW Melly is part of this gang, he must have killed these 2 people? I'm curious what you think about the connotation regarding G Shine Bloods, gang, and we're listening to all this.
Yeah, absolutely. But that could actually be part of trial tactics, right? You want to get the jury to feel and to emote in a way that's not so overwhelming, but gets.
What's goody, y'all? We about to get started. Day 11. Welcome to the broadcast. Ooh, this trial whooping my butt. Make sure y'all hop on here, man. Hit that thumbs up for your guy. I'm happy, though. It's Thursday. It's like, it's Thursday. No court tomorrow. Okay. Guess they waiting on the jury or something to do with the jury. I'm still wondering who this witness they were talking about at the end of court yesterday. I'm wondering who this witness is. Man, I bet you that prosecutor don't get any sleep. You heard her say she doing a triple homicide case. She got like 2 other cases going on. And she got to do the YNW Bortland, a.k.a. Cortland Henry, Mr. Demons, a.k.a. Melly, co-defendant. She has to prepare for his trial, too. I'm like, well, I can see why she's doing his trial, but golly, they ain't got any more prosecutors in that county. Yeah, because it seemed like she in charge of all the cases. All right, let me put a poll up. We gonna keep it simple. Cool breeze. ATL.
Hello!
Y'all sit back, man. It's the last day. It's the last day until
the
the 10th.
Day 8 of the double murder
You know,
trial
I'll
for
still
rapper
be going
YNW
live,
Melly to
but I
start
won't
up.
be on early
24-year-old
like
Jamell
this,
Demons
but,
stands accused of killing his 2 friends back in October of 2018. And as we wait for the proceedings to start up this morning, I do want to talk about the juror issues that arose last week. As we spoke about in the last block on Thursday, an undercover detective was called to the stand to give insight on gang culture and to protect his identity. He was masked, and while this didn't really sit right with one juror, and they were actually brought in to have a little conversation with Judge Murphy about it. Let's take a look.
Messages during the last witness's testimony. And the first one said, I don't feel comfortable. Why does he get to see us, but we can't see him? That's your message to me?
Yes.
And the second was, I need a moment. I can't listen properly. When I was a child, I seen someone get robbed and am having an anxiety attack.
Yes.
And I guess my concern is, are you able to sit as a juror, or you think this is too much for you? I'm trying to figure out, and that's why we took a little extended lunch break to figure out whether you feel comfortable and you're up to it.
Yes, I feel comfortable, but I just don't think it was appropriate for someone to be masked up like that. And plus, you guys didn't even tell us. Like, you don't know what people have been through, so it just it shocked me, a shock. So, yeah. But I do feel like I can handle it. But that just wasn't appropriate.
I'm sorry?
I said I don't believe that was appropriate.
Well, some things I make certain decisions about things, and then we go forward with it, and I instruct jurors. And are you think you'd be able to follow those instructions, and you pay attention to the evidence, or do you think that you're concerned about the masking that is going to affect your ability to follow the instructions and follow the evidence?
Yes, I can listen and follow the evidence now that I know he's going to have on mask. I can listen.
And the anxiety issue, we're past that, you're okay?
Yeah, I took my medication.
Thank you.
Dr. John, we talked about this before. It's a unique situation. I've never seen it before. You have this witness who needs to be concealed for safety reasons. I've seen that. But making this a juror issue where jurors extremely uncomfortable, Judge Murphy made the call by letting them continue to serve on the jury. He didn't, excuse this juror. And I'm curious if that was the right decision in your mind, because to have this juror step up and say, I don't think it was appropriate, and say that they were triggered by this, I mean, do you want that juror sitting on the jury?
I think it comes down to the statement that she had made, which was, I just didn't know, right? Had she had known that this individual was going to be testifying in a mask, right, in particular in a mask, then...
For preserve the record, we renew our objection to the witness testifying with a mask.
Judge, we're good. All right, bring it.
Jury entering.
Let the record reflect the presence of the defendants as counsel. Please be seated. The assistant state attorney will come to the jury and our witness, Danny Cole. Please have a seat, sir. I just want to remind you that you remain under oath. All right?
Yes, sir.
So you all had a nice weekend, ladies and gentlemen. I think we're going to pick up where we left off on Thursday. So, Madam State, I think you're still on your examination of this witness.
That's correct.
You may proceed.
Thank you. You are the same Detective Danny Polo that was here last week?
Same one, different suit.
Okay. Same mask?
Same mask.
Okay, we had left off on page 24, publishing what is going to be into evidence as State 70. Okay, going on to, this is still the chat with the number that's saved in as Gino. So going now, I'm going to skip ahead to page 28. I want to make sure it's visible so everybody can read it. The name G-O-O-N, Goon.
Yes.
Is that an individual you were able to identify?
Yes.
And who is that?
His name is Isaiah Eberhardt. I don't think I'm pronouncing the last name correctly.
Okay, going down here. The message that is coming in from the ending in 9807 phone number. What in this particular message from September 29th of 2018 tells you that this is somehow affiliated with G-Shine or GKB?
The first indication that it's blood related would be taking out the letter C from creeping, putting a K, and then the second one would be the use of the term herc, which is common to be used between members of GKB. themselves, address each other.
So going now to page 29 of State 70, and the message from Gino, contact on October 4th of 2018. With regards to this message, if you could please read it aloud for the jury.
You are a truly talented, beloved. It's an honor to lead you. Thanks for the opportunity. I won't let you down.
Can you make any opinions or conclusions from that message about the relationship between the person identified as Gino and the person who's on the other side of the conversation ending in 9807?
Well, the first thing I want to note on this message is the word honor is in all caps. That's one of the it's one of the words associated to certain G-Shine blood symbols: honor, respect, loyalty. So the fact that Gino made that all caps is indicative of just showing more additional blood-related language. Gino's expressing to the 9807 number. I got that right, 9807?
Yes.
9807 number, that he's that person, the 9807 number, is a talented individual, and he appreciates the opportunity.
Can you say about the rankings or the hierarchy between the two?
Based on the previous messages, Gino is one of the subjects that was above the 9807 number. He was one of the subjects involved in recruiting the 9807 number.
Okay. The response from the 9807 number, is this again using those same codes that you previously talked about on Thursday?
Yes, he says always, and he's just responding to the messages, and he calls him Herc, which is a common G-Shine, like saying bro or dude or something like that, or brother. DL stands for down low, which means I hear you, and SL is shine love.
Okay.
It's G-Shine, shine love. It's one of the terms they use.
Okay, going to the next message on page 29. And if you could read that one aloud for the ladies and gentlemen of the jury.
Quando denied saying anything about you, Q or the hood.
Can you tell the ladies and gentlemen of the jury what the hood is normally used to refer to?
The hood would be the blood organization or G-Shine organization. I mean, specifically here, he mentions that he didn't say anything about, or he denied saying anything about not just the hood, but Q. And Q would be Jaquan Burton. That's what he goes by, Q-Shine.
And so the last two messages from the 9807 number and then the response from Gino. A little bigger, sorry.
9807 said, ain't worried. And Gino, he's gonna get his day, mark my words.
So I'm going to go forward, page 30. The message of October 6, 2018 at 12:05 a.m. If you could read the one that is right there in the center of the screen.
All right, Gino states, I'm on the line with Tall Godfather, GF. He wants a sit down with you and Jay Green. Jay Green is Jalen Green, one of Mr. Denman's associates, who happens to be part of a different G-Shine set. Me, you, Jay Green, and him.
Okay. Going now to that same page, the message on October 8th of 2018, 12:43 p.m. Can you read this message and then translate it, please?
To stay in tune is to communicate, bro. If you feel like it's too much, you can line up elsewhere, but you won't get the perks and respect you get now. The choice.
What does that translate to?
So based on context from the messages I read, the 9807 number wasn't checking in and communicating with members of Gino's lineup, Gino's set enough, and he's letting the 9807 number know that if it's too much for him, if he can't follow the rules and check in as it's required, then he can pick a different set, different blood set, different lineup. Specifically uses the word lineup elsewhere, but he's saying their set has the most respect.
Okay, so going to page 31, I want to go to now the message from the 9807 phone number on October 23rd of 2018.
Just says beloved.
And then going on to October 24th of 2018 at 12:37 a.m. What does that message show?
The GKB or G-Shine, Gangsta Killer Blood, Oath.
Okay.
They go by many names, like I stated before.
Is this the same that was reflected in some of those emails that you had previously discussed?
I would have to go to the email and make sure see if it's word for word the same, but it's consistent with the G-Shine Oath.
Okay, and that was previously admitted as State 69. And State 68. Are the other two that we've run so far. So,
Thank you. You want to know what page I'm on?
please, if you could refer to one for that.
Page 4, under the rules, says oath / red alert. And I'll read directly from here first. I take this oath and solemnly swear to uphold, honor, and respect the rules and regulations that govern the Empire of Shine under the banner of the United Blood Nation. I take this oath to be responsible, trustworthy, and militant, for I am a reflection of this hood, and in parentheses, empire. From this day forward, I will no longer think or act as an individual, because I know my actions can affect others. I take this oath and swear to be there for my brothers and sisters in a time of need and give them a sturdy shoulder to lean on, for my loyalty lies in G-Shine Empire.
So this one's a little bit different on that.
Right.
Can you explain to the ladies and gentlemen of the jury why there may be a difference between those two?
These Bibles, books of knowledge, they're handwritten most of the time or typed up like this, as you can tell. And this is probably like a notepad application on a computer. And everyone, as they learn it, they write it down. And you know, if you've ever played the game of telephone as a child, little things might change from one text to another. But for the most part, I believe it's pretty much almost the same.
Okay, going to the next message on October 24th.
Pardon, can we approach?
So we got the mask expert back on the stand, Danny Poland. It's not a replay, I guess it's been recalled to the stand. I didn't think we were done with the other guy. Like, for real, I didn't think we were done with the expert from yesterday, the reconstruction guy. Were we? I thought she still said she had redirect and... Oh, man.
gentlemen, I need a few minutes with the lawyers. Just put your notepads down, please. Don't discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case. Thank you.
Okay, they got a motion. They about to. Okay, they got some litigation going on. Some lawyering. He looks so tired of this.
Thank you. Let the record reflect the jury stepped out. Counsel remain on with the
Boss line, Tanner. That's good. Hey, Melly don't look like he worked millions, though. They got him in there looking broke as hell.
Was previously stated, as you're objecting to this witness testifying wearing a mask. Based upon his testimony, I overruled the objection, and now you're suggesting you want to revisit that?
Yes, sir.
So go ahead and tell me, make your argument.
May I inquire from the witness?
Sure.
Sir, are you aware that your picture, along with your family, is on the internet as we sit here today?
Nope.
May I approach?
Oh,
You
so
may-
this is a replay.
Same thing you showed Counsel Seibel?
Yes.
Thank you. Go ahead.
I wonder what the delay is.
I show you what is a picture and ask if that is you and your family,
Yes, sir.
and that's on your wife's Cash App,
Yes, sir.
which is available to anyone who runs that, because we just ran it this morning.
I guess so. I did my best to keep things clean. I guess I missed that one.
We
Oh,
would
yeah,
object to
this is-
him continuing to
Well, it
testify
must be some kind
with
of
his
delay
mask
with the jury
on
or
based upon that as a
a
public
witness.
record.
Yeah, this is nothing that this witness put on. It was something that was done by a family member that he was unaware of. So based on that, and the testimony is still truthful and accurate as to what he has done to protect his identity on that. So based on that particular item, I don't think that rises to that
Hey,
level.
make sure y'all smash that thumbs up, man. Hit that thumbs up, y'all.
Thank you.
Subscribe to the channel.
Take a few
Please,
step
and
down
thank
for a second, just wait outside.
Yes, sir. Your Honor, I have a request.
Yes.
Can I briefly call my wife and make sure that she scrubs everything that I might have missed?
Sure.
Thank you, sir.
And Judge, we just asked to have defense counsel not to preserve that because that is something that if it got out, there would be concerns for the safety of the witness on that. It's already been seen by the court and be described as such, but to preserve it or anything else on that that could lead to safety issues for this witness would be very troubling.
We have no problem with that.
So that's agreed. All right. So, I'd like to hear what the witnesses finds out from his spouse. I guess my concern is, it's always something we're trying to balance things. With the defendant, anything to discuss? No? You need a restroom break, Ms. Dennis?
No, sir.
All right, we're in recess. Thank you.
It's always happens when.
Or co-defendant Cortland Henry were part of a drive-by shooting that claimed the lives of their friends. But authorities say that something happened otherwise, citing evidence of the shooting taking place from inside the vehicle. Prosecutors claim, that this was a staged drive-by shooting. Joining us live from the Broward County Courthouse this morning is Law and Crime's very own Terry Austin. Good morning, Terry. It's good to see you. You were inside that courtroom for all of the drama. I want to start with the state calling this reconstruction expert to the stand yesterday. I thought his testimony was pivotal. It took up the entire day. What were some of the bombshells that he dropped?
I I think he was excellent too, Jesse. It was pivotal. The bombshell is that he corroborated what the medical experts said, what those MEs said as far as the injuries to the two victims in this case. He said that Christopher Thomas, who was sitting in that back seat, he died from a gunshot wound in the cheek, and that the other bullets that he had were sustained subsequent to his death. And he corroborated that Anthony Williams, who was in that front seat, also died from that first shot to the head, and the other bullets were sustained after his death. What he also said was, look, there were two projectiles found in that car, and based on his investigation, none of the bullets were where they said they should be. Henry went into that hospital. He was interviewed, and he said that the crime took place at a certain location, and Sergeant Christopher Williams was able to say, no, we did not find any casings there. It was at another location. So I thought he was very good at corroborating what the medical examiner said, and also what the other investigators said as far as where that drive-by took place.
And just to amplify that and clarify that, so he said the shooting happened from inside the vehicle. Did he say it happened where the defendant was sitting, sitting in that car? Because remember, the defendant was sitting in the back left-hand side, and if I recall correctly, the shots were to the left of the heads of these victims. Did he clarify that it could only have happened from where the defendant was sitting?
Well, that's right. He demonstrated different scenarios, and on cross-examination, David got up there and he basically said, this is the attorney for the defense, he basically said, look, could there not have been other scenarios? Could not that shot have come from outside of the car? And the sergeant continued to say, no, it had to be from inside that car. And he said that the other scenarios were not supported because of the blood spatter, and also because of the trajectory of the bullets. He kept saying it could not be from the outside. And I think what defense was trying to do there is to say, but you didn't consider that that is a possibility, because you're saying that it couldn't have happened. And he actually got up there and demonstrated, why couldn't it have been like this from outside of the car? And they showed that jury the 4 chairs as if the people were actually sitting in those chairs so they could understand where the bullets were coming from. So, yes, he did say it had to be in the back seat. He did say it had to be on the left side. And, in fact, he even said once it could have been Henry based on the height of all of the individuals involved.
And we know that Henry, I believe, was driving the car, so that becomes an interesting question. Now, the cross-examination, you mentioned it a little bit, the points that the defense was trying to make. Walk me through what were some of the points you think they made. And also, I believe it's going to go into cross-examination today. Where do you think they're going to go more with cross-examining this reconstruction expert?
Well, they just began the cross-examination, so I think they're going to try to hit home that these other possible reconstructions could have been a reality, and it didn't have to be from inside the car. I think he's also going to try to establish that we don't know it was Melly. It could have been anybody. We know he got in the car because of that video from the studio of him getting in the car, but we don't know what happened after that. So 2 things, Jesse. One, we don't know exactly who it was sitting back there, and we don't know if, in fact, it was someone who was sitting back there. So the possibilities are endless. And I think what we're going to try to establish on the defense side is that's exactly right. He has not proven, the prosecution, she hasn't proven beyond a reasonable doubt that it was Melly in that car, that he was holding the gun, and that it was he who shot the 2 victims.
Can I tell you, I'm a little surprised at the prosecution, because didn't we hear yesterday that they have more of a case to present? My understanding was the defense wanted to put on their case, and the prosecution was like, no, we got more witnesses. What can you tell us about that?
Well, there was a little, acrimony between the 2 sides about a notice of a deposition. There's one witness, Trevion Glass. He was in, remember, there were 2 cars in the studio parking lot when they were leaving, and there's this red Mitsubishi, and apparently Trevion Glass was in one of those cars. He was in the second car, and he has been noticed for a deposition, and the prosecution was basically saying, this is a last-minute notice, but the defense literally just received the address, and there was some, scheduling issues as far as whether or not he would be deposed and whether or not he would actually respond to the subpoena. So that's one of the witnesses that the prosecution is saying they want to call. I don't know if that person is going to show up, and if not, we won't see him. But basically, the prosecution is saying, look, we do have a little more before we actually rest.
Yeah, do you have any idea about who else the prosecution might call, or even how long it's going to go for?
Yeah, the prosecution actually said they had one other witness. It was unclear who that witness was. So the expectation that I'm hearing so far is just two individuals, Trevion Glass and this other individual. After that, I believe that will be the end of the case because they haven't mentioned anyone else. As I said, they already had all of the medical examiners. They've got this crime scene reconstructionist. I think that was probably one of their most important witnesses. He's tying everything all together. One thing I noticed, Jesse, is that we do a poll on the YouTube, and so far it has been up in the 70s as far as not guilty. It went down a little bit yesterday and the day before, and I think it was because of the medical examiner and also because this reconstructionist sort of tied in together what the medical evidence showed.
Yeah, I agree with you. I think this is testimony that we have been waiting for to establish the shooting came from inside the vehicle and possibly where the defendant was sitting. Do we have any idea about the defense's case? They seemed ready, primed to go. Do we know which direction they're going to go in?
I'm positive they're going to have a crime scene reconstructionist who's going to say that it is absolutely possible to have someone outside of that car shooting, and that you cannot definitely tell, that the other bullets were bullets that were received after the individual died. So they might have a medical expert on as well to sort of refute the two main pieces of the prosecution's testimony that's gone in so far, that medical exam and that reconstructionist. They have to address those issues, in my opinion. If I were defending this case, those are the two areas that I want to focus on. And Jesse, they may also have individuals who were in that other car. I don't know at this point if they're going to call them. Yep. So, that remains to be seen.
And let me ask you about the defendant. We're showing right now B-roll video of him in court. How did he behave yesterday in court? Because as we always say, he was quite animated the first few days, yawning, smiling, laughing, blowing kisses, anything like that?
He has been very serious, Jesse, as this trial winds down, as the prosecution's case begins to get to an end here. I think maybe he's heard what people were saying online as far as him being so animated, but I think for the last week or two he has been extremely serious, focusing, looking at the monitor so he can see what the exhibits are showing, looking at the witness, focusing very much on what's going on in that trial. And he looks also out to the audience to see his family. He smiles when they come in, and I think that gives him some comfort. Yesterday, his mother was there as always, and his grandmother was there. We also saw his younger brother come in, and they have a very close relationship, and I definitely think that makes him feel a bit more comforted.
Anybody else in the courtroom there? Maybe the supporters of the victims, the family members of the victims at all?
The courtroom is separated in two areas. The area on the left side is for the defense. The area on the right side is for the victim's family. They have come in and out, but the presence has not been sustained. I think there have been times there have been more. I believe the mothers of the victims have been in there. They don't stay for the duration. I know for a fact when they put up those photos from the medical examiner's office, they had a hard time and went and stepped out. So it's not as full on the other side. I'm sure it's a very difficult case for them, and perhaps that's the reason that they haven't been coming all day, every day.
Understandable. Terry Austin, thank you. Great reporting. I know you have to head back into the courtroom, and we'll make sure to check back with you later. Thanks, Terry.
Thanks, Jesse.
All right, everybody. For now, we're going to take a quick break here at the network, and when we come back, we're going to see if we can go live. In the meantime, we want to show you a special report from Sierra Gillespie.
you doing? All right, court's now in session. The Honorable John Murphy. Presiding.
All right, y'all. I tried something different. I tried to let it get ahead a little bit today. Jump ahead of some of these little breaks. Hopefully get to
Good morning, guys and gals. Here's Miss Smith. She here?
She's outside of the next She just walked out of the phone.
The weather conditions are
Perfect.
perfect. I don't know if I should give the court credit or Gary credit.
Gary, not me.
He's arrested.
For those videos, do you have an objection to that?
That's it now.
Yes.
No objection. Defer to the court, of course.
Sharon, the next witness.
We don't have court reporter.
Oh, yes. It's just on scheduling in terms of we're going to call the witness out of turn because she's a record custodian and we'll get her out here.
Does that mean you're asking Sergeant Williams
Yeah, we can
to
just.
step down? I want you to wait for a minute.
Nice way of saying get out of there.
You should do that.
Not too far, though, not too far.
Couldn't resist. I mean, it was.
What's up, y'all? Y'all kind of just in time because it started already, but I kind of like letting it play catch up. So y'all just in time. This will be the last day of court, I believe, until July 10th. So, starting tomorrow until court is back on the 10th of July, we'll be starting at a later time and obviously discussing other things going on. But we getting close to the end of the state side. The state, I believe, has a couple more witnesses before they rest their case. But that won't be until after they get back from till they get back from break. So state will be on until after the July 10th resuming of court. But make sure you guys hit that thumbs up for me. Please subscribe if you haven't already. And thank you. I can't stand when they talking and we can see them and we don't know what they're saying. Some of the legal experts pointed out some of the stuff I've been saying for the last couple days as far as these poll numbers. It's still overwhelmingly in favor of a not guilty verdict in some of the polls, but those numbers have they've started to even out a lot. So,
President is the defendant, his counsel, the assistant state attorneys. I understand, ladies and gentlemen, jury ready to proceed. State ready?
Yes, sir.
Defense?
Yes, sir.
And it was made clear to me a few minutes ago that the state's next witness is going to be called out of turn. There's no objection. Is that right?
No objection, Your Honor.
All right, so let's do that. Bring in the jury. Pardon me?
81.
Jury entering. Read that back. Okay. Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the jury, the defendant, defense counsel, and state attorneys. Ladies and gentlemen, I trust you had a nice night, and we're ready to begin now. The state indicated that they wanted to call a witness out of turn. Detective Sergeant Williams is here, but he's just waiting outside. There's a short witness the state wanted to put on now out of turn. The defense indicated they had no objection to that. So we're going to call that witness first. Who was the witness?
Sean Newman.
Good morning. Are you Ms. Sean?
Yes.
Welcome. What I'd like to do is just remain standing, raise your right hand, and be sworn.
Do you solemnly swear or affirm the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Wait a minute,
Legal
who
name
is
for the
this?
record. Say
Tashawn Newman.
Please spell your first and last name for the court reporter.
Is that his
First name
mama?
is Tashaun. Last name Newman.
Thank you. Please have a seat.
Is this?
I want the record to, Ms. Newman, there's a microphone in front of you, it's pointing straight up, but you can move it down, all right? Just that way. You all set?
Yes, sir.
Thank you. Counsel, you may proceed.
Thank you, Your Honor. Good morning.
Good morning.
Can you state your name and where you're currently employed?
My name is Tashawn Newman, and I work for the Florida Department of Transportation Turnpike Enterprise.
Okay, and what is your role or your assignment currently?
I am the account research manager. I oversee the department that does extensive research into accounts, as well as we fulfill public records requests.
Okay, and prior to your position as an account research manager, what was your position?
Financial investigator.
And what were your duties as a financial investigator?
A large portion of that position was fulfilling public records for law enforcement as well as for our legal department.
Okay, and in this particular case, back on or about October of 2018, did you receive a subpoena, not you specifically, but the corporation, receive a subpoena regarding video surveillance from October 26th of 2018?
Yes, they do.
And in the form of legal service, correct? For
Correct.
either subpoena or public records?
Yes, ma'am.
And did you fulfill that request?
Yes, I did.
And are video surveillance kept in the normal course of business by your department?
Yes, they are.
And are they essentially made out or near the time of the event, here specifically October 26th of 2018, and routinely kept?
Yes, ma'am.
Your Honor, at this time, I will be showing defense counsel to mark this case quadruple F for identification purposes. May I approach the witness?
Yes.
And Ms. Newman, did you have an opportunity prior to your testimony to review the USB?
Yes, I did.
And what is it?
It's a USB with various videos of the toll roads on the express lanes.
From October 26th of 2018?
Yes, ma'am.
Is it in the same or substantially the same condition as when you last reviewed it?
Yes, it is.
Any alterations or deletions that you can see?
No, ma'am.
Your Honor, at this time, the state reviewed this evidence states quadruple F, that states 81.
Is there any objection?
No, sir.
Thank you. It'll be admitted.
States quadruple F, A mark states 81.
No request to publish at this time, Your Honor. No further questions.
Counsel, is there any cross-examination of this witness?
I have none, Your Honor.
Thank you, madam. Thank you very much. You may step down.
Thank you.
You're excused. Who is your next witness? We're back on with Sergeant Williams.
Yes,
We ask Sergeant Williams to come in, please.
Yes, sir.
It'll be a minute, ladies and gentlemen.
Ooh-wee. So, wow. So there's obviously they have some type of video. The defendant's car, some type of turnpike. I don't know, but that was interesting. I'm really curious as to what significance that has to the trial. Because they still trying to put him in the car. The defense keeps saying that he's not in the car. There's no evidence he was still in the car. So maybe they, Ah, lordy, lordy, lordy. Make sure y'all let me know what y'all think in the comments. Is that it? Okay, he got a little new suit on, or at least a new tie, it look like. That's what I'm talking about. I don't think that turtle.
With the defendant, anything to discuss? No? You need a restroom break, Mr. Dennis?
No, sir.
All right, we're in recess. Thank you.
It's always happens when.
So they back in recess, y'all. Lordy, lordy, lordy.
We run the city. We run the city.
But that's why I did it like this. So we ain't gotta go through all that. Well, let's hear what these clowns got to say.
And thanks for coming back to Law and Crime, everybody. Day 11 has just begun in the YNW Melly double murder trial, where 24-year-old Jamell stands accused of killing his two friends back in October of 2018. Now, before the break, we were listening to the cross-examination of the state's reconstruction expert. And although he's not done with his testimony, the state just called a witness out of order this morning. So let's start there and see what's going on.
Thank you, Your Honor. Good morning.
Good morning.
Can you say your name and where you're currently employed?
My name is Tashawn Newman, and I work for the Florida Department of Transportation Turnpike Enterprise.
Okay, and what is your role or your assignment currently?
I am the account research manager. I oversee the department that does extensive research into accounts, as well as we fulfill public records requests.
Okay, and prior to your position as an account research manager, what was your position?
Financial investigator.
And what were your duties as a financial investigator?
A large portion of that position was fulfilling public records for law enforcement as well as for our legal department.
Okay, and in this particular case, back on or about October of 2018, did you receive a subpoena, not you specifically, but the corporation, receive a subpoena regarding video surveillance from October 26th of 2018?
Yes, they did.
And in the form of legal service, correct?
Correct.
Either subpoena or public records?
Yes, ma'am.
And did you fulfill that request?
Yes, I did.
And are video surveillance kept in the normal course of business by your department?
Yes, they are.
And are they essentially made out of near the time of the event, here specifically October 26th of 2018, and routinely kept?
Yes, ma'am.
Your Honor, at this time, I will be showing defense counsel to mark this case quadruple F for identification purposes. May I approach the witness?
Yes.
And Ms. Newman, did you have an opportunity prior to your testimony to review the USB?
Yes, I did.
And what is it?
It's a USB with various videos of the toll roads on the express lanes.
From October 26th of 2018?
Yes, ma'am.
Is it in the same or substantially the same condition as when you last reviewed it?
Yes, it is.
Any alterations or deletions that you can see?
No, ma'am.
Your Honor, at this time, the state will move this evidence states quadruple F, that states 81.
Is there any objection?
No, sir.
Thank you. It'll be admitted.
States quadruple F, mark states 81.
No request to publish at this time, Your Honor. No further questions.
Counsel, is there any cross-examination of this witness?
I have none, sir.
Thank you, madam. Thank you very much.
Okay, rather short but sweet there. So, Jamie, it seems to me that really she was just called to authenticate what is going to be surveillance footage, if I heard that correctly. And I find it interesting because I was wondering, would the state just finish up their case after the state reconstruction expert? But clearly not. They have more that they want to introduce. What else do you think that they want to do in their case?
Well, I think they're trying to help the expert as far as his conclusions. And I think this particular witness, while they didn't go into great detail, which surprised me, I think, she probably could have put people in a particular place if there in fact was surveillance that she was the custodian of. And so I think we're going to hear more. If we're going to hear any evidence, it's going to be in the attempt to help out this particular expert with his conclusions. And I think that's what this witness was all about.
And hey, look, y'all. My man got on a corduroy sports coat. I just had to point that out. That man got on a corduroy. I ain't seen that since the 90, 80. What?
Now, Doctor, we're still kind of left with thinking about this week. I'm reflecting on it myself. And, you know, I think that yesterday and the testimony of the medical examiner, maybe the surveillance footage, that's going to resonate more for me in this case in terms of who the actual shooter is. I don't know how much all of the motive evidence helped. Whether I'm talking about the idea that the defendant was part of a gang, and whether or not he killed these two individuals to show his oath or loyalty. Now, of course, that evidence will be important in terms of if he's convicted and this goes to...
Let's get back on the record. We all ready to proceed?
Yes, sir.
All right, read your name. Very entry. Gentlemen, thank you. Please be seated. Let the record once again reflect the presence of our defendant, Mr. Demmons, his counsel, the assistant state attorneys, ladies and gentlemen of the jury, and our witness, Christopher Williams, Sergeant Williams, remains on the stand. Sergeant, I just remind you, you still remain under oath, all right? And I think we're in the middle of your cross-examination.
Yes, I have nothing more for Sergeant Williams. Thank you.
Okay. No further questions. All right. Is there any redirect?
Yes, Your Honor. Good morning, Sergeant. How are you?
Good morning, Ms. Farley.
So with regards to the autopsy photos and things that you reviewed, how were you able to get the approximate shoulder width of Mr. Thomas?
So the medical examiner's office, they use a scale it's a big ruler that goes the length of the autopsy table where the decedent is lying.
Okay. In terms of that, so you got that 2 feet 6 inches from approximately?
Approximately.
Okay. In terms of, counsel asked you with regards to the multiple times as to how did you rule out that someone was outside the car? Why? Why did you do that?
And that was explained in them also multiple times. It's the blood that was on the headliner, the lack of blood in the passenger side rear seat, and the GSR that was inside the vehicle.
Okay. With regards to ejection pattern testing that counsel asked you about, if you're going to do an ejection pattern, what would you have to do?
You'd have to have the firearm, and you'd have to have the ammunition to conduct that test.
And in terms of the time frame on the casings, is it important to find them immediately after?
It would be very important to find them immediately after.
So a month delay in finding them. Could you do ejection pattern testing if it's a month later?
You can, well, if you have the firearm, you can do ejection pattern testing. How it would apply to on the side of the road, you would have to do that on the side of the road with that firearm.
And if individuals have gone back and picked up casings from the scene, how would that affect ejection pattern recreation?
Individuals as in strangers?
Or people that were friends with the defendant. If they went back to the side of the road.
Objection, Your Honor.
If individuals went and picked up casings, not knowing they were involved.
Objection. There's no evidence of that.
As that question's over, or the objection's over,
So if they were picked up, it could alter it, but at the end of the day, it still needs to be measured.
So in terms of the shots that are in this vehicle, how can you tell the approximate distance that the shots were fired from?
The approximate distance is obviously going, as I said, this is a unique case where our shooting is contained to a vehicle. So we have known distances within the vehicle. We have known distances of the, not necessarily the arm, but we have a known distance of inside of the width of people, and the stippling pattern that is on Christopher Thomas, who's on the back seat, and some of the stippling that is observed on Anthony Williams, who was in the front seat.
What about on the outside of the car? How can you tell that that wasn't shot from a mile away?
You can tell that it wasn't shot from a mile away by the angle of it and its type of impact into the vehicle. So if it's shot from a mile away, the projectile is going to start tumbling again. It's going to go head over heel. As it loses velocity, as it loses its spin, it's going to start wobbling, and then eventually will start going its head over heel and then keyhole into its target.
Did you see any evidence of distant fire in this case?
No.
In terms of the defendant in this case, you said you measured him?
Yes.
Do you recall about what date that occurred on?
Can I repeat it?
If you need to refresh your recollection, please do.
November 30th of 2021.
And at the time that you measured him, was it here in the courthouse?
Yes.
And that's where your office was at the time?
Yes.
And could you describe his build?
He's slender, but he's tall but slender.
Okay. And in terms of, would you say that he has broad shoulders?
No.
And you said he was 5'6", right?
Correct.
In terms of that car that we were talked about, what's the best way to get an idea of how big the inside of that car is?
You can measure it, or you can also view it.
And where is that car right now?
That car is in the crime scene unit forensic processing garage right now.
Is it available for the jury to view this morning?
Yes.
Here, if we may approach.
Now we about to take a field trip. Are we taking a field trip? They not gonna be able to show that, y'all. That's just gonna be too much. Would you have a cameraman walking and trying not to catch the jury on film? I don't know how this gonna play out. Why are they doing all? I don't know, y'all. You think they gonna take him to the garage? I just seem like the defense didn't do a good job yesterday for her to have to do this. Like, everybody pretty consistent with, like, yesterday was a W for the defense. They just want this guy up here for as long as possible, I think, because he been handling the defense. This prosecution witness, Sergeant Williams, he really been handling the defense pretty good. I don't know what to make of this. I really don't. If y'all just joining, please make sure y'all hit the thumbs up, subscribe to the channel. We taking in Jamell Demons, or State of Florida versus Jamell Demons, aka YNW Melly, double murder trial. That's what we waiting on a decision, I guess, from the judge as to whether he's gonna take the jury outside to see this car. And I guarantee you, he's probably telling the state that he don't think that's necessary. It's just gonna delay everything. They gonna have to. Let's see.
Thank you, sir.
Thank you.
Madam State, who's the next witness?
Judge, we're just requesting a 5-minute recess to set up some videos for the last review.
All right, ladies and gentlemen, take a short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence concerning no research.
Before we even get to that, Jamie, let me turn it to you. At the end of you just heard the redirect, relatively short. It seems like he's been excused. What do you think the jury is going to take away from this crime scene reconstructionist? In my opinion, one of the most important witnesses we have heard from. What do you think the jury is going to take away?
Well, without contradiction, I think they're going to find that this incident happened inside the vehicle. There doesn't seem, while the defense has, through their questioning, suggested that there could have been somebody else, the scientific evidence at this point in time is really uncontradicted that, the shooting happened inside the vehicle. Whether or not it was Mr. Demons or, the other gentleman, that is something I suppose the jury could argue about. But I think that based on the witnesses that we hear today and the other expert, it's going to be very difficult for any reasonable jury to find anything otherwise.
Now let's talk about the jury visit to this car, which I believe is at the courthouse property. Maybe we'll get a chance to see what's going on with that. But Doctor, let me ask you this. How important is it for jurors to actually see a crime scene? We talked about it in the Parkland school shooting case, where they closed off that school and the jurors went to a site visit. We were told it was a very, very emotionally taxing day. In this case, I think the car is central because, again, that's the crime scene, and it's trying to understand whether or not it was a drive-by shooting or happened in the car and where everybody was situated. What do you think the jury is going to take away from that?
Yeah, not only Parkland, but Murdoch as well, where you get an understanding of just the geometry, right? Forget the trigonometry. You get an understanding of what the whole thing felt like, where you get to see everything. And I think it's such a huge and important thing that can happen for a jury, to more than just the pictures, to actually be able to physically see with your own eyes all of the evidence that's being presented, including a car like this. I think it's going to be massive.
And Jamie, what can't they do? They can't get in the steering wheel, right, and drive it around. They can't make their own demonstration. Walk me through what they can do and can't do.
Correct. So, they'll be escorted through the process, and they will be able to ask questions. The prosecutor, or at least a representative of the prosecutor and the defense attorneys, will be present, and they'll be able to ask questions. Those questions will be recorded. They'll be made part of the record, but they will not be able to get in the vehicle. They will not be able to conduct their own experiments. And this is one of the dangers, I guess, as far as jury visits are concerned. Judges usually frown on these for very logistical reasons, but there's also a very practical reason, and that is that sometimes, especially when you get into the science, people bring their own personal experiences to bear. And when you start going outside of the courtroom and looking at scenes, while I agree with the doctor that it could be very beneficial, it also creates an opportunity for juries to sometimes step outside of the court rules and start drawing conclusions outside of the evidence. And that's the danger here. But they will be able to do their own visible inspection, and they will be able to ask questions, and draw some conclusions based on those observations.
Doctor, do you see that same kind of concern?
I do see it, but I think a good instruction would let them know that listen, you're here to take a look at what's going on. You're here to experience it. You're not here to all of a sudden start doing your own experiments. So I think a good instruction would probably alleviate some of those concerns.
Yeah, and we seem to be coming towards the conclusion of the prosecution's case. We talked about who the defense might call. Jamie, if the defense calls their own crime scene reconstructionist that says the complete opposite of this witness, and we're speculating here, how does a jury sort that out?
Well, I don't know that they do. I mean, that is the definition of reasonable doubt. And, again, I'm not privy to the witness list, but I would be shocked based on the cross-examination if there isn't a defense witness that is at least going to challenge some of the math. There's been some conclusions drawn mathematically, and it pertains to blood spatter evidence. And, none of this sort of evidence is certain. There's always a degree of nuance. And if they bring their own expert who says this could have happened a different way, I think that is the definition of reasonable doubt, if it's a credible expert.
All right, well, we're not there yet. We're going to see what happens if the jury goes on this site view, and maybe how long that'll last and what they'll take away from that. So it should be an interesting morning. We'll follow the latest here on Law and Crime. Stay with us. Our focus will be on YNW Melly, but of course, we're on Verdict Watch in the Scott Peterson trial out of Florida. Take a quick break. We'll be back right after this.
Last week, I was plowing the back 40s and having my tractor. I climbed underneath the tractor, on top of me. That pig ran over, put his shoulder under it, pushed it up, and I managed to get out, and the pig saved my life. Traveling salesman doesn't know it. Is that way else his leg? Oh, I said no. I said, so what happened? He's alive. Farmer said somebody they were very cold. 2 weeks ago, the house caught on fire. We were all sound asleep. Pig went through there, blink, woke everybody up. My whole family got out safely and saved all of our lives.
Charlotte.
I think that's amazing. Right? Yeah, I think so. Come on.
Uh-oh. Uh-oh. Gotcha, bitch. Charlotte just said guilty, all caps, man. Just cut to the chase, right, Charlotte? Make sure y'all hit that thumbs up, hit that subscription button for your boy, man. We out here, man. We out here.
We run the city. We run the city.
Yeah, I mean, no, not really. You are what you eat.
Well, you have like, honestly, they don't go there
Well, it doesn't look. Did they walk down there already? Or, like, I know they ain't did that fast. I know they did not go to the garage that fast, so unless he's gonna make a ruling out loud in the court. Ooh-wee. There's a lot of silence in the court today. I mean, it's a lot of stuff they haven't.
Thank you. Let the record reflect the presence of the defendant, Mr. Devens, his counsel, the assistant state attorneys, ladies and gentlemen of the jury. Ladies and gentlemen, I think their state's ready to publish. Is that correct, counsel?
Yes, Your Honor.
What exhibit number is this again?
State's publishing states 81.
81 in evidence.
Yes.
Give them the license.
For record purposes, I'm going to begin with I-595, eastbound and westbound express, 1026-18, 0320 through 431. Eastbound lanes.
Well, as you can see, I think Cool Breeze was right earlier when he said that he believes that they're gonna I don't know if from this angle we'll be able to see like any marks on the vehicle or not, or it could be to show how many silhouettes, because you definitely are not going to be able to see inside the car from this angle. Let's have other angles. Hey, Jazzy.
Hello.
You definitely aren't going to be able to see anything from this angle. So man, I'm really curious. Thank you guys. Hit that thumbs up for me, please. Make sure y'all share it to your Facebook, Instagram. Spread the word, man. Dopest TV, one love or no love. If the that's all I can keep saying, y'all, is Cause I'm looking at the other cars pass by and I can't. They're gonna have to put it in super slow mo. They gonna have to put it in super slow mo. I hear some people commenting. See some people commenting saying, I thought the highway footage would be better quality than this. It's at nighttime, first of all. Second off, it doesn't look like they've slowed it down a bunch or anything. I'm trying to get to the good stuff. They playing. They playing on our top. Oh. Bro, are they gonna skip to it? Oh my God! Chat, what are they doing? What is going on? This is what we pay for. I guarantee you half your tax dollars that go to the legal system is wasted on them sitting around like, what is going on? They take more bathroom breaks. Like, remember when we used to get recess? It used to be so hard to get your teacher to let you out to go use the bathroom after we just came back from recess. I'm sick of it. I am sick of it. This is crazy. Okay. Oh, they do have a little side angle. They do have the little side angles jumping.
Yeah, nothing really happening. I mean, it's hard to tell what we're seeing here. Nothing, no indication that we're seeing the car that was the crime scene car, the car that actually where the shooting took place. Maybe you guys are seeing it more than I am. But Jamie, let's go back to the conversation about the death penalty, because I was talking to Dr. John about it. What is your thoughts? We have 8-4. That's all that's necessary to vote in favor of death if the jury ultimately convicts Mr. Demmons.
So Florida is certainly one of the more prolific states when it comes to death penalty cases, especially when it comes to African American men. So I'm from Michigan. We haven't had the death penalty for more than 100 years, and I'm personally and philosophically opposed to it. But if I were to take that hat off and be objective, in Florida, my understanding is that it's really a case within a case. So this will not be the jury that determines the death penalty. It's my understanding there'll be a second jury impaneled. I could be wrong on that, but I do believe that is the process. And in order for that jury to make a determination that a death penalty is appropriate, they'll have to make a determination that the mitigating factors are available. And certainly murdering two of your friends over a gang situation would fulfill one of those factors. But there also has to be some empathy, I suppose, associated with the victims. And what I'm hearing is that the victims really don't have a lot of family in the courtroom, or to the extent they have been, they've been in and out. And that's the kind of evidence that will compel 8 people to determine that death is appropriate. And if there isn't any sort of background associated with these gentlemen, that could be a problem for the prosecutor as far as seeking death.
Yeah, I actually want to confirm that. We'll find out if it's a separate jury or the same jury. We'll get back to you on that one. And now it's interesting because you think all murders are terrible. How do you know which ones are qualified for the death penalty? But clearly, I think it's the gang aspect of it, the brutal nature of it, the multiple murders. You can see why it would rise to the level that the prosecution is moving forward with, again, but you would need to convict him in order for this to happen. Now, let me ask you this, Doctor. We're seeing a case here where the prosecution doesn't have all the pieces of the puzzle. They don't have the murder weapon or weapons. There's a serious lack of DNA from the defendant. I mean, what was it, last week we learned that his DNA wasn't on a ton of key pieces of evidence. It was on I believe, the door handle on the left-hand side. I don't know if that's that surprising. We know he was in the car. Do you think that that's going to give the jury pause?
See, here's my problem with the scientific evidence that gets presented nowadays, and it's always colored by.
Me that way. I don't have an opinion one way or another. But despite all the horrific evidence and despite conviction, they may still feel that the death penalty is not appropriate. Again, go back to the Parkland school shooting case. That he had pleaded guilty, so it was just a question of whether or not he was going to be sentenced to death. And that jury heard all the evidence, and it was horrific. One of the worst school shootings, mass shootings we've seen, and they still voted life in prison. So it's kind of unpredictable.
It is, and thank you for clarifying. It differs from state to state as far as the procedures associated with the death penalty and
If I was on the jury, I'd have been asleep already. I'm gonna be honest. If I was on the jury right now, I would be asleep. Definitely. I don't know. It's a jury.
That communication. What the importance of that communication? what exactly it is this particular street gang does, how they communicate with one another, the importance of that communication, what each member of the gang is designed to do, what they're expected to do. I think it did a good job of delineating that information, but the jury thinking that all of a sudden that rises to the level of killing your two best friends, I think that there's still a little bit left to be desired there. I don't know that they're quite there in understanding why someone would do that.
By the way, let's go back to what we expect the jury is going to happen for the jury. They're going to go on this site visit. They're going to continue for the rest of the day. Then there's a week off, Jamie. There's a full week off. There's no court next week. Is that I'm wondering if the prosecution rests by the end of the day, and it's as opposed to if their case is continuing onto the week after. I don't know if this is going to benefit them, benefit the defense. What do you think this week-long break will do?
100% benefits the defense, because at the end of the day, if they have a week to de-think what they've heard and the defense comes in and could put on some kind of credible case, that is always the position that you want to be in as a defense attorney. So, a week of them, not only not in court, but on vacation with family and friends, and then to come back and hear
Thank you. Let the record reflect the evidence set out. Counsel remain along with the defendant. So the videos, these are things
Media production, those already been entered into evidence. The extraction would be the next thing the state would be publishing, which would be the 300 photos that we had pulled out to show the defendant's phone.
So let me see what's on the.
Sure. And I think we had already done some of these, but I'll start playing them.
Listening deep, and bro, don't be speaking on me, bro. I don't do that. You don't do that. Ben, I got to listening deep.
Thank you. So these videos are just to show ownership of the phone?
Ownership of the Snapchat account.
This is the most important shit here. Like, get right there, like, you know you come back.
That was the video we previously edited, Judge.
Before we tell me all that extra shit, and like, they need the most important shit here. Right, yeah.
So, stop for a second. Which ones are you saying are need a balancing, 403 analysis?
Well, many of them are either way before this incident or way after. I don't know what the relevancy is.
She's explained to me she's trying to establish who owns the Snapchat account because there's a dispute as to ownership of the account. That's the way I understand it. Is that correct, madam?
Yes, sir.
Could we just see that last video again for a second?
This one? That's highlighted?
I know on these videos before there was an objection and I took out firearms, and there's also one with
money and cash.
All right, anything like this on any of these?
Yeah.
Do you have anything on any of these?
The next one as well? They both?
This one?
Yes.
This bitch look like he got 5 kids at the student pickup right now, waiting.
Do we know who Snapchat is based on what we just saw? Whether it was the other gentleman or Mr.
What's the 403 analysis?
Well, the relevancy, the 401 analysis. Right?
I heard 403.
No,
All right, so
401.
relevance on past because they're trying to establish who owns the account.
Okay.
So the relevance objection is overruled. What's the 403 analysis?
Okay, I understand, Your Honor, that it is overruled, but I'd just like to actually make the argument, which is, if their purpose is to establish ownership because of who is depicted on the videos, that would be undercut if we're seeing other people depicted on the videos. That does, if the person on the video establishes who owns the account, then it might be the other person's account. So that just shows that the argument does not carry weight. As far as the 403 analysis...
You can argue that to the jury. You can argue that to the jury.
Okay, I want to put my relevancy argument on the record for the court to consider. As far as the prejudice is concerned, Your Honor, in each one of these, it depicts Mr. Demons in a what may be, and we've only seen it. One thing we want the court to do is see them all, not assume the balance of them is not going to contain information that may have a 403 objection. So we first want to see them all and not be ambushed and try to unring the bell after.
You haven't seen them?
We haven't seen the ones, we haven't had them identify the ones that they intend to play. I mean, they give, if you download some social media with millions of items of information and then come in here and cherry pick some to show, we need to see what they intend to play so that we can have some basis to either interpose an objection or not.
That's what they call a motion in limine. You file a motion beforehand, say, Judge, we need some determination as to all of these videos, which ones they're using or something along those lines, so we're not sitting in here while the jury's sitting in the jury room saying, what are they doing out there?
The other reason for the rules of evidence and the need for authentication is before they admit it into evidence, at the time they establish its relevance. So this is the time for that. Not us asking, looking at 16 million items and saying, out of these, we are going to ask you to eliminate 14. The proponent of the evidence is the one that carries the burden of establishing the relevance of the evidence they propose to admit. And at that time, the relevancy or 403 objection becomes ripe because of what is ensued in the trial and what is left to be proven. And that is our position, Your Honor. And it seems that they only have maybe 8 more and they're a second apiece. I'm not quite sure what the prejudice would be to having them go through them so that the court can see what it is.
So it's clear for the record, Your Honor, that is all the videos on Snapchat. That's the entire production that was sent in. So we're not cherry picking in any way, shape, or form on this particular exhibit.
So how many are there?
There's 5 more, Judge?
17.
Could you go back to the one before that for a second?
No, counsel, we're just going to go through it. We're going through all of these. Let's just get it done. Thank you.
So the one that we would have an objection to primarily is the one that they have 3 versions of towards the end with music lyrics in the background saying that that and will kill you. That we think is objectionable. It's not his voice, it's a song in the background. This is
Play it
over.
again. Thank you. What's the position of the state?
That is sent to one of the witnesses and that it is a threat to them and also an admission to the incident we have here today. So I'm going to cross-reference in just a moment with
What's the date on it?
11/22/18.
I'm sorry?
11/22/18.
and that was sent to, hold on. So that was sent to two different individuals that then are in these responses that are showing on the screen now, Your Honor. That there is a message that was sent from the defendant. It was a reply. That was a post that he had put on November 22nd, 2018. Then through the three messages on items 5, 6, and 7 are responses indicating that Mr. Demmons had posted that specific message online and acknowledging it, that they had seen it as one of his stories at that point.
Your Honor, the state just represented initially that they were putting on this evidence to establish the owner of the phone. We then recognized that to have been a pretext because now the state is claiming that the purpose for those highly prejudicial videos is to show that they were sent to a witness. When asked to prove that, the state is demonstrating that it was posted online and somebody responded to it, which is not what the state said. It doesn't show it's being sent to a witness, and it's not for the purpose of establishing its phone. That is his phone, and it contains lyrics that are prejudicial, and we object on 4 of 3 grounds.
Wish to say that?
Judge, we can always play it without the sound if that's what defense is concerned on, and it still shows that it is his.
You're saying, though, the messages reflect that there's a threat?
It does, Your Honor, and I think that is relevant, and based on the time frame of when it was posted after the homicides, that it is something that should go before the jury. But Your Honor, if Your Honor is going to make the balancing call on that with regards to if the audio portion is considered too inflammatory, the video portion can be played without any audio.
So what do you need the Snapchat account for?
So in terms of the information's already been identified as Melly, Montana, as belonging to the defendant. And if you go on down here, this particular message, which is authored by the defendant, sent to Ms. Hamilton, saying that the individual known as Port, also known as Portland, saved in the phone, which is this co-defendant Cortland Henry, says that he saved the life of Mr. Demmons, and he's coming everywhere with him because if the crackers come grab him, it's my fault. That is November 9th of 2018. In addition, Your Honor, so here's the entire text of it. Make it easier to read.
Hey, real talk, y'all. If y'all see some of these polls right now, it done went from 69% yesterday to 60%. So I told y'all, man.
So in addition, Your Honor, the name, Melly, Montana. In addition, the Melly.Montana name links back to the Celebrate, which also helps show and support that the phone in state 64 belongs to the defendant.
With respect to the statement itself coming in, our position would be that there is no contextual reference of what it refers to. These people have known each other for a long time. Outside of that, if that is what they're using as the predicate for needing the Facebook account in evidence and the court deems it to be relevant, the state has offered to play it without the prejudicial audio, and we think that would be an acceptable compromise.
Thank you. Anything else contained in this Snapchat that has that you're alleging as threats against witnesses? Because I haven't heard anything about a threat to a witness.
No other words.
Pardon me?
No other of those, no.
All right. So regarding what counsel is objecting to, the audio portion of those three Snapchats, I agree with it. On a 403 analysis, take it out. So how long did these run?
Those would take about 10 minutes, and then the state would be intending to publish the 300 photos that we previously identified and showed.
Show the counsel with 300 photos?
Yes, they were the ones that we previously shown. And so in terms of to make it clear which ones are published for the record, we can put this in to explain the thumbnails and then identify them as by the image number on that, as opposed to putting the entire file name for each image in.
These are the extractions from
State 64.
which is
With his cell phone.
research. And this is for the purpose of establishing that.
It's his phone.
These are the ones that we okay.
You can look at all those if you want to look at them.
The actual photos themselves, you have those, which is
Well, as I told you before. So, for example, if the file is you have a special codec installed.
okay. These are those, right?
Yes, they're just, sure.
Boy, how public opinion is swaying in this case, y'all. Public opinion is swaying in this case. I'm sitting here watching it. I'm watching the comments from different media outlets and polls. This is wild. Now it's 35%.
Councilor, you
not
indicated,
guilty.
I mean, there were phones
35.
showed it to me
It's
the
a
last
13
time, and I indicated those had to come out. Talked about sexually compromising positions as well as guns. All those type of photos are out.
The photos that are there would be ones that show the defendant's face, either on FaceTime calls or anything of that nature. There's no firearms that were in the photos that I showed Your Honor. It's my recollection. But the defense counsel is reviewing them again, and I can put them up on larger format if they need.
I mean, I saw basic things that council showed me, 2 pictures in particular, which I agreed with, and they were overly prejudicial, not probative of anything, and they should come out. So you're saying there's no pictures in this exhibit that discuss that, is that correct?
Correct, Your Honor. And I'll verify again.
Could we have some stickers for a second?
Sure.
Thank you very much.
We're in recess.
Thank you.
Devin, do you need a restroom break?
Melly.
Do you? Yes? All right, can we arrange that, please? Mr. Bailey? Yes, sir.
Session with the Murder on My Mind rapper and his co-defendant Cortland Henry in the car. Although Demmons and Henry claim that this was a drive-by shooting, authorities have reason to believe that the shooting took place from inside the vehicle. In fact, we heard from a crime scene reconstructionist yesterday and today who said that. Now, what is happening in court is we are outside the presence of the jury and we're listening to arguments between the attorneys and the judge. Let's see what's happening.
That there is a message that was sent from the defendant. It was a reply. That was a post that he had put on November 22nd, 2018. Then through the 3 messages on items 5, 6, and 7 are responses indicating that Mr. Demmons had posted that specific message online and acknowledging it that they had seen it as one of his stories at that point.
Your Honor, the state just represented initially that they were putting on this evidence to establish the owner of the phone. We then recognized that to have been a pretext because now the state is claiming that the purpose for those highly prejudicial videos is to show that they were sent to a witness. When asked to prove that, the state is demonstrating that it was posted online and somebody responded to it, which is not what the state said. It doesn't show it's being sent to a witness, and it's not for the purpose of establishing its phone. That is his phone, and it contains lyrics that are prejudicial, and we object on 4 or 3 grounds.
Wish to say that?
Judge, we can always play it without the sound if that's what defense is concerned on, and it still shows that it is his.
You're saying, though, the messages reflect that there's a threat?
It does, Your Honor, and I think that is relevant, and based on the time frame of when it was posted after the homicides, that it is something that should go before the jury. But Your Honor, if Your Honor is going to make the balancing call on that with regards to if the audio portion is considered too inflammatory, the video portion can be played without any audio.
So what do you need the Snapchat account for?
So in terms of the information that's already been identified as Melly, Montana, as belonging to the defendant. And if you go on down here. This particular message, which is authored by the defendant, sent to Ms. Hamilton, saying that the individual known as Port, also known as Portland, saved in the phone, which is this co-defendant Cortland Henry, says that he saved the life of Mr. Demmons, and he's coming everywhere with him because if the crackers come grab him, it's my fault. That is November 9th of 2018. In addition, Your Honor, so here's the entire text of it. So in addition, Your Honor, the name, Melly, Montana. In addition, the Melly.Montana name links back to the Celebrate, which also helps show and support that the phone in date 64 belongs to the defendant.
respect to the statement itself coming in, our position would be that there is no contextual reference of what it refers to. These people have known each other for a long time. Outside of that, if that is what they're using as the predicate for needing the Facebook account in evidence and the court deems it to be relevant, the state has offered to play it without prejudicial audio, and we think that would be an acceptable compromise.
Thank you. Any other, anything else contained in this Snapchat that has, that you're alleging as threats against witnesses? Because I haven't heard anything about a threat to a witness.
No other words.
Pardon me?
No other of those, no.
All right, so regarding what counsel is objecting to, the audio portion of those 3 Snapchats, I agree with it. On a 403 analysis, take it out. So how long did these run?
Those would take about 10 minutes, and then the state would be intending to publish the 300 photos that we previously identified and showed
Show
here.
the counsel with 300 photos?
Yes, they were the ones that we previously shown. And so in terms of, to make it clear which ones are published for the record, we can put this in to explain the thumbnails and then identify them as by the image number on that, as opposed to putting the entire file name for each image in.
These are the extractions from
State 64.
which is
With his cell phone.
research. And this is for the purpose of establishing that.
It's his phone.
These are the ones that we will create.
Hey, look, I'm gonna be honest. Because we get to see all this stuff, the jury doesn't.
Sorry, I told you before.
Some of which is not going to be admitted into evidence.
So, for example,
Some of which will be admitted into evidence. They'll get to see that portion, but they're not going to get to see and hear this audio and stuff that we saw and getting to make their decision. But look, man.
On Delatorre, but also joining the conversation, criminal defense attorney Bridget Williams. Bridget, good to see you. So all of this is really important to establish that the phone in question, the phone that we knew was triangulated by a cell phone expert to possibly show the location of the defendant in the car and with the victims on the night of the killing, that this was his phone. The defense seemed to suggest maybe this was a phone that was used by multiple people. What are you thinking of? What are you taking away from what we're hearing here? This is all outside the presence of the jury.
Yeah, it is all outside the presence of the jury because they're trying to decide if this is evidence that should be heard by the jury. And so we go back to, one, the fact that the prosecution has the responsibility to tell defense counsel all evidence that they intend on presenting at trial and if it's relevant to the case. And so they should be discussing that with defense counsel prior to. Now, we're at the point now where the prosecution is trying to say, well, they're using it for specific purposes. And defense counsel is saying, well, no, you're not allowed to use it for that. And so I'm very curious to see, one, if the court will allow it into evidence. I think I heard something along of Melly's Snapchat that they're also discussing about bringing into evidence as well. That is also a reason why defense counsels generally are talking to their clients about what they post on social media. Things that you post on social media can and generally are admissible in court, in trials and hearings alike. And so it's very important to guard what you post on social media platforms because it can and will be used in trials and hearings going forward in cases that you may have.
That's a good point. Let's take a break, and we're going to talk more about this, maybe with Terry Austin, our boots on the ground, who can give us an indication about what's happening and also what was the significance of that surveillance footage we were seeing earlier. So stay with us. We'll be back.
Cool Breeze said, damn. Let me look at this poll. It's still sitting at 60%. Man, it dropped 8 percentage points just from yesterday. Just from yesterday. So I guess Cortland Henry, aka YNW Bortland, is gone. I wonder if his trial is going to be streamed or televised or whatever you want to call it. I don't even think they use televised anymore. I wonder if it's going to be streamed. Because as you can see, I think this is some of the evidence that they may be using in his case. These Snapchat messages, obviously the medical examiner. I mean, all the same. If you think about it, I think they don't use pretty much a lot of the same witnesses. They may even have more because we don't know who he's texted and spoken to. Obviously, they both were a little bit too loose on their devices as far as talking and texting and doing all that other stuff. But I anticipated at the beginning of this it was going to be a lot of not guilty votes and in these polls. And as the evidence played out, I kind of assumed that it would start to even out. I believe it's going to be like 50-50 from the public standpoint. As far as the jury, I'm leaning the jury because, again, like I said, we get to see a lot of stuff the jury doesn't even get to see. Right, Ms. V. He in the Star. Let me see. If the jury was able to see what we see, this case would be over. I agree. 100%. I agree 100%. I think it's at the point now for most people, it's not did he do it, it's can he beat it. And I'm going to be honest, if the jury is not sequestered, I don't see how they don't hear about this stuff. Like, this ain't the 90s and the 80s. How do you, like, this is the biggest trial going on right now. I mean, actually in session. I think Young Thug's trial will be equally as big, if not bigger. But, how do they not hear, you know, and then they're going to be out of court for a whole week. They're going to go to 4th of July celebrations and be around family, friends, and strangers, and nobody's going to say nothing. So what, they have to delete everything off their phone? Like, that's wild. I don't know. Like I said, oh, thank you for the super chat. Dopest Melanin. Thank you, love. Yeah, that's what I'm saying, Miss V. Like, how's that gonna work? So look, they're gonna come back from this, then they're gonna go right back to
explanation and
lunch
no
break.
witness. It was just cars going up and down the highway, but we have no idea what those cars were. So frankly, I think it was 15, 20 minutes of sort of not much happening.
What was the jury doing?
They were looking at it. They were sort of leaning over. I did see a couple of them sort of saying something to the other. I don't know what they're talking about. Maybe, you know, why are we watching this? I can tell you that the audience was talking and wondering what we were looking at and why we were looking at it with no explanation. But we all just sat there and waited for it to conclude. There were a couple of times the prosecution went up to put on a second video to show what was going on in the video, just to mark it for the evidence to say this is from point 1 to point 2, but that was it. No other explanation about those videos. So it's in evidence. It's been published. The jury has it. They can take it back if they want because now it's in evidence, but no explanation thus far.
Now, talking about a car, my understanding is the jury is going to go on this. It's not like quite a site visit, right? They're not going to another location. They're going to check out this car, which is in the forensics garage of the courthouse. Walk us through that, what we can expect.
That's exactly right. It is in the forensics garage. We have requested to go down and view the car and the scene as well. I think the jury is going to have the opportunity to look at those chairs. Yesterday, we saw the chairs in the courtroom, and they were just courtroom chairs where we were trying to depict where the 4 individuals were seated in that car, driver, passenger, and the back driver, passenger. Now they're going to get an opportunity to see how large are those seats, who could have sat there, whether or not it was possible for someone in that back driver's seat to hold a gun and shoot someone next to him and shoot someone in front of him. So I think logistically it's going to help the jury make a determination as to whether or not that's possible. I think they're also going to wonder outside of the car, is it possible to lean in and lean over and take those same shots? So very important information for that jury to see that car.
But they have to be careful, right? They can't make their own kind of demonstration or recap of what happened. That's usually not permitted.
That's my understanding as well, Jesse. They'll just go down, they'll look at it. The judge will probably, as judges normally do, instruct them not to have any conversation, walk around, take a look for themselves, you know, see for themselves just how much room is in that car. It's right downstairs, as you said, in the building, in the garage, on the first floor.
Right.
Hopefully we'll get an opportunity to go down as well.
Now, let me ask you this. We were just seeing this back and forth between the attorneys and the judge outside the presence of the jury. It was regarding, I think, evidence that prosecutors want to submit to show that this was Demon's phone. What was that about?
That's exactly right, Jesse. There's a Snapchat video, several Snapchat videos, where the prosecution wants to determine who owned that phone. Defense was saying, look, there are lots of people in that video. You can't determine it. The argument is whether or not it's relevant under 401 and whether it's prejudicial.
His counsel and assistant state attorneys, juries in the jury room, did you get the pictures worked out, counsel?
We're about 98% of the way there, Your Honor. Shaking it up.
Okay, so here we go with this again. The judge don't even know whether to sit down, keep walking around. So, did they take the jury to? No, I'm sure the judge would have went too. I don't know what's going on. What's the delay? I'm really surprised they let that video play of the freeway or turnpike or whatever the heck, the highway, without, I didn't hear the prosecution say anything about what we were looking at, or I didn't see it. I did not see it. Let me check on the. It's gardening day, of course. Thursdays. They should be back in a second, though.
Tori, let me ask you this. The site visit, the visit to the car that the jury is going to see, it's at the courthouse, it's in this forensic garage. What is the impact that's going to be for the jury going there, this kind of field trip that they can't necessarily get within a courtroom?
Well, it's huge because it's contextual, right? Because you get to see it now, right? You get to see it. It's more than just a picture. It's more than just testimony. You actually get to physically see it. You get to compare yourself to some of these things, right? You saw the images from the crime scene reconstructionists with the rods and stuff like that. You get to see all of that stuff yourself. So I think it's going to be massively important.
And Bridget, what do you think about it?
I agree with the doctor here. It is going to be very important. However, it is a thin line here where you have jurors who are going to this site to look at the actual car, that they may be taking into account their own mind of what they think may have happened here. And so that sometimes can be a tricky situation because you don't want jurors coming up with their own analysis of what happened here. You want them to make sure they keep in mind the evidence that's being presented, and then they're taking into account what the witnesses have been talking about before, and then they're just using that to really just analyze what's going on here in person.
That's a good point. And then we were also hearing about the evidence that the prosecution wants to use to establish that was Mr. Demon's phone. But we are coming towards the conclusion of the case, the prosecution's case, one way or another. Dr. Delatorre, how confident are you in the prosecution's case? Because they've thrown a lot out there for this jury to consider, that, and particularly this week, that this was a killing done on behalf of a gang, and that he staged it to look like a drive-by shooting and made sure to get out of there before his co-defendant went to the hospital. A lot for the jury to accept.
It is a lot for the jury to accept. And I think right now I'm at like 95% that he has done it. Like I said, you know, we live in a world of infinite possibilities, but we only have finite probabilities. And I think going to see this car, the pictures from the crime scene reconstructionist, I think some of the testimony from the undercover officer about gang culture, I think all of that is going to lead them to a decision that aligns more heavily with the prosecution. And we'll see what the defense has.
Yep, I agree. I agree. I'll tell you what. So before they took their recess, the attorneys and the judge, they were having arguments. We didn't get to the last little bit of them. I want to watch some of it. Let's take a look.
Counsel, you indicated, I mean, there were phones that were showed to me the last time, and I indicated those had to come out. Talked about sexually compromising positions as well as guns. All those type of photos are out.
The photos that are there would be ones that show the defendant's face, either on FaceTime calls or anything of that nature. There's no firearms that were in the photos that I showed Your Honor. It's my recollection. The defense counsel's reviewing them again, and
I don't know if the state has any objection. I thought they had no objection to removing those.
There's no objection to removing the firearms, that some of those were left in there. They were inadvertent on there. There was two that just wasn't clear that that's what it was until the defense counsel pointed it out. But as to the money and things like that, those are images that were taken on the phone. Sometimes there's 5, 6, 7, 8 shots of that particular outfit or whatever the issue may be on that, which shows that the individual has all of the photos. That's not just the one that's posted to social media. So it's important to show that there are multiple takes to get the best one that's later posted to the social media websites.
Thanks. What's the objection regarding the money? Shots of the money?
It's not relevant.
For the same 403 grounds that the court introduced the subject of money earlier, which is to the extent that it might be off, I'm not quite sure what the court's thinking is, but to the extent that it might be off-putting to see somebody flaunting their means, we think it's unnecessary. Plus, there's an unnecessary, as far as the 403 balance is concerned, if the state's purpose is to establish the ownership of the phone and they're putting in 300 photos, if we take out 20 photos of marginal relevance and potential prejudice, and I think the 403 balance clearly weighs in favor of exclusion. It's cumulative, and it's also cumulative and unnecessary. And what the court has in hand and is handing back are the hard copies. The reason why we're taking so much time and we're over there with the state is because there are some digital images that the state was unable to print, and as among those, there are fewer that we seek to exclude, but they would be for the same reason. And the state would have to, at some point, go and take those out of the digital image, which would be removing, it's either money or guns. And I think that's it.
And you're saying that the pictures related to the money are important because why?
Showing who is using the phone. There are multiple images of the defendant in terms of he'll be taking 30 and 40 photos on one day, but only one is posted to social media. This is to be able to make an argument later on to the ladies and gentlemen of the jury that this is the person who had that phone, who was using that phone, because there's only one, the best image that's selected, that's put on social media.
Also suggesting to me that there, in that array of photographs there, that photographs with caches, 20 or so approximately, where he's flaunting funds, and there's more than enough to establish the point that you're trying to establish.
So Your Honor, in addition to that, there's been no testimony that it's real money. In terms of that, there is movie and prop money that's referenced in other places in the phone. For example, there are notes in the phone in which the defendant has a wish list of things where he says he needs fake money to do a video shoot on that. So I don't think there's any undue prejudice on that in saying that there's any sort of financial means.
Anything else?
No.
I don't think it's necessary, so sustain the objection.
Okay, so we'll go through and then create a new selection of those photos with defense, and that way we can get that forward to the ladies and gentlemen of the jury.
And how long is that going to take?
About 45 minutes.
So I'm going to bring the jury in now, send them to lunch, tell them to come back at 1:15. Does that give you enough time?
Yes, sir.
You know, before we do that, I'm of the impression, and I might be wrong, and I stand corrected if I am, that this concludes the evidence that the state has to present today, absent the court ruling that the jury can go and view the automobile. And we have been presented with a written motion that they have fashioned very quickly, nice and efficiently. We would want an opportunity to respond. And so we would object to the viewing of the vehicle today. And if they're going to take 45 minutes of the jury's time to take out photos digitally, and that's all they're going to do when we come back and play them, we might as well conclude and pick this thing up on the 10th when we return. So that's just my suggestion, and it's predicated on an understanding of what the state has left to present.
Thank you. So what is it that you need to do to prepare for the motion to do a jury view, counsel?
Well, look at some research, particularly with respect to the purpose for that the state has advanced, which is to demonstrate the dimensions of the inside of the cabin of the vehicle. If it is to do that, the jury going and viewing a vehicle with 5-year-old congealed blood in it, a total scene, we might very well be able to find a substitute automobile that is clean, that we can rent, that will serve the same purpose. So if the court is of the opinion that the state is entitled to have the jury examine the dimensions of the vehicle, they can do it in a clean vehicle where there's no prejudice. So we want an opportunity to go rent one so they could go and see it, opportunity to find one that is of exact dimension so there'd be no prejudice, and proceed that way, and an opportunity to research whether or not under the circumstances they'd be entitled to do it at all.
In addition to that, Your Honor, we'd ask the court to review the Judge Siegel's order denying the state's motion for review by jury of the proposed scene on the grounds that there are numerous photographs. The exact language is, the state has ample evidence from which a jury can gain an understanding, and in this case, the place where the alleged shootings of the vehicle out of 27 occurred. And as such, the court, Judge Siegel, denied that jury. There are plenty of photographs of the Jeep. I think the state introduced somewhere in the area of about 40 to 50, possibly more, photographs of the Jeep. There's no need to do that, but if the court is considering it, we obviously need time to do a little research on it.
Here in the state would suggest I asked defense counsel numerous times if they wanted to view the vehicle and be able to make an accurate determination of that. They've declined to do so on any prior occasion. The vehicle is downstairs. If Your Honor and defense wanted to look at it to understand that it is not gory or gruesome in any way at this point, there's no bright red bloodstains or anything like that, I would suggest that that would be important for defense counsel and Your Honor to see before making any such determination.
Well, a couple things. Number one is that I wasn't aware that Judge Siegel already ruled on a motion for a jury review.
Not of the car. That was done with regards to transport the jurors to the scene, to give them an understanding of the time and space from Fort Lauderdale to the edge of the Everglades. So that was a separate with regards to a jury in terms of transportation and things of that. So
You're suggesting what Mr. Adelson just represented to me had nothing to do with the jury view of the vehicle.
Correct. That is correct. I said the scene. And if the court misunderstood me, I apologize if I did not.
I didn't hear that. Regardless, counsel, I spoke with Mr. Tom Wolf, who advised me that you mentioned to him this morning about the jury view. He came to me, and then I got a call from Captain Tianga telling me that it would basically be impossible to do a jury view today, that if they were going to do it, they needed time and wherewithal to a secure area because the jury view would, I assume, require the defendant to be there. They'd have to be unshackled. His counsel would have to be there. You'd be there. I'd be there. The jury would be there, and it would be. They'd have to secure the area. And what was explained to me by Captain Tianga is that's not a secure area downstairs, and he is concerned about it. So he said it couldn't be done today. And if you went so far as to ask for a jury view of the scene from Judge Siegel, I would have thought you would file a motion pre-trial regarding seeing a jury view of this as well. And you didn't, and I would have thought you would figure that out before you say something to the jury that it can be done or would be done. You know, that's the way it was. The implication I got. I would just think you'd clear that with the court before you start telling the jury about it. In any event, so we're going to bring the jury in. I'm going to tell them to be back at 1:15, and you go ahead with your publishing. But according to what I've been told by BSO, a jury view isn't happening today. So we can talk about the motion. We can set it down for hearing next week or tomorrow, whatever you all want. We'll figure it out. We'll pick a day and we'll talk about it. But it's not going to happen today.
Understand.
All right, bring the jury in, please.
So look, y'all. That's a good thing that we don't have to go through the viewing of this. At least I'm not up for that. I'm really not up for that. It seems like you know what I'm gonna do? While they at break, I think I'm gonna go over to this other trial. What's the guy name? Ronald Bourgois, I don't know, but he is the dude accused of taking the life of his mistress and I believe their 1-year-old child. Ms. V says, I think the view should be when they return, so it will be fresh in their minds when the defense starts their case. I agree. Let's do this real quick. Is it not live? Hold on.
if you had access to the time it took for the signal to be sent and returned, then yeah, you could certainly make that calculation.
I kind of been peeping this trial out on the side. If sometimes you see me turning to the side or looking at my phone, it is wild how every, especially murder trial, has cell phone experts. Like, that's a hell of a gig now, to be like a cell phone telecommunication expert and become a witness in that. They getting paid. These expert witnesses get paid now. Don't get that, man. They make like sometimes $20,000 a day. Yeah.
That Google location data, Google provides location data that may be drawn from a number of different telecommunication sources. Is that correct?
From different sources, yes.
Yeah, from different sources. And so some of those are GPS satellites.
Correct.
Okay, but also you mentioned it could be from cell phone towers.
Correct.
Bluetooth, conceivably?
There is a Bluetooth component, but nothing in my report regarding the Bluetooth.
Okay.
It seemed like he talking real low or something.
Cell phone location information from other or nearby cellular towers?
Well, that would be the cellular, yes,
okay.
sir.
Internet protocol address information?
It would be from Wi-Fi. I'm not sure if that's what you're referring to, IP, but yeah, I'm not sure where you're going with that.
So the data that's produced, geolocation data that's produced by Google, could come from any one of these different sources, correct?
The Google location data that's provided in the location data report either comes from cellular, Wi-Fi, or GPS, nothing else.
Okay. And are you saying that the only data points in your report that you used or reported about were drawn from one source of those data, or
two sources, from GPS and Wi-Fi.
Okay. And what is the accuracy of each of those in terms of its ability to identify location?
So Google, in addition to providing the launch determined by Google, it also
And Anjanette Levy is going to be on soon for our lunchtime Q&A, where we take your questions about the case. But since they went to a break a little bit early, we have some time to answer your questions a little early. So here we go. So I want to go to criminal defense attorney Bridget Williams. I'm going to throw this one to you. At Reggie Rants 1 from YouTube wants to know, if Melly isn't talking and Bortland's testimony doesn't add up, talking about his co-defendant, does the jury just go with forensics and that there were 4 people in the car, with Bortland being a driver and with Melly sitting where the shooter shot from?
Well, that's a great question. Thank you for asking it. I'm going to start with one, that the defendant has a right to remain silent. He does not have to testify. He does not have to say anything. And the jurors do not and cannot use the fact that he's not talking against him. So let's start there. After that, the jurors have the responsibility at that time to only consider the evidence that is being presented by the state. The defense counsel doesn't have the responsibility to put up any evidence. It is the job of the state to prove every element beyond a reasonable doubt. It's not the defense counsel's job for that. And so it's the jurors have to take into consideration all the evidence that the state is presenting and then determine if that allows for every element to have been proven beyond a reasonable doubt or not.
Let me go to you, Doctor. We got a question from at Yana Lore Love 3129. This is from YouTube. What side do you think the jury is leaning more towards? An impossible question.
Yeah, it is an impossible question, but I think the problem is that the answer really depends on who's presenting evidence at the time. Naturally, people are going to align themselves with the person that's presenting the information to them initially. So right now, I'm going to say that they're aligned with the prosecution, but that doesn't mean that they're going to automatically create a verdict that's in favor of the prosecution's case. That's not necessarily the same thing.
Right, because the cross-examination by the defense could be really strong, and they might be holding on to that and waiting to hear what the defense has to say. Bridget, we got a question from FBG Duck GTA 5 from YouTube. Wouldn't one of the victims have heard the shot first and ran if Melly was the only shooter? I guess the question is, how quick could you be if you're YNW Melly to shoot both victims at the same time? Now, of course, there could be a question whether Henry was also the shooter. They believe that Melly is the shooter. It could also be, in my opinion, right, that the shock, right, the shock of seeing that. But I throw it to you. This question wasn't to me. This question was to you.
No worries. That's a great analysis, Jesse. I'm going to start with just saying that, well, from the reconstruction expert, he discussed that the initial shot, the fatal shot, came from within the vehicle, right? And it came from the back seat from where what the state wants us to believe where Melly was sitting at. And so that is where the initial shot came from. And it was a fatal shot. And so according to the reconstruction expert and according to the medical examiner. And so after that one shot happened, then it's fatal. They died immediately. There's no running. They died. And so according to what the state is presenting here, that first shot was the fatal shot. And so getting to the other shots was just something to cover it up, according to the state.
That's a good point. All right, doctor, we go to Tammy Blanchard from YouTube. What benefit is it to look at a vehicle that has been at the scene of this crime going to prove? Is it to encourage the jury?
What benefit is really just about placing into context the testimony that was there. Now, again, you don't need it, right? I'm not suggesting that anyone needs to see it, but hearing the testimony and seeing the pictures, right, you only get a 2D view of that. When you get to go see the actual item where the item is presented to you, then you get a three-dimensional picture of what's going on. You get to walk around it and think about what might the testimony actually have been suggesting when you're in front of the item that they were talking about.
Yeah, I think there's a benefit, especially it's this kind of condensed area. It's there. It might help them a little bit to determine whether or not this shooting could have happened. Or like in relation to the question we had before, could someone in his position, Melly's position, sitting in that car, kill both people at the same time? All right, we got a question for you, Bridget, at Trilisha Morns 2141 from YouTube. How will the defense combat with the evidence that the state is presenting? Circumstantial evidence is just like physical evidence, right?
Not necessarily. When we are talking here about what defense counsel will bring up in evidence on their case in chief when it's their turn, it's I'm interested to see what things they're going to be bringing up. They're going to be, I think, maybe even bringing up their own reconstruction expert to point out the flaws of what the reconstruction expert for the state discussed, in addition to just pointing out the fact of that the reconstruction expert only talked about that the shots came from within the vehicle, and he talked about that there was a stationary person that shot into the vehicle. And so, but he doesn't have any testimony regarding that it was in fact Melly that did the shooting. And so the state to me hasn't done a thorough job to say, okay, well, this was Melly and they put the gun in Melly's hand. There's not a shooting gun from their point of view to say that it was Melly. It's all circumstantial. And so the defense counsel, I believe, has done a great job of showing reasonable doubt throughout the prosecution's entire case in chief. I'm not 100% sold, and I don't think, and this could be my defense mind speaking, but I don't see the prosecution here, showing every element here beyond a reasonable doubt. I'm not there yet.
And you're not convinced by the crime scene reconstruction expert, the medical examiners that said the shooting happened from inside the car. I thought that was pretty significant.
Well, I mean, I'm convinced that it happened from within the car. I'm not convinced that it was Melly.
Okay. Well, I tell you what, this is a good question. This is a question from @CBrad742 from Twitter. Was gun residue found on Melly? My answer is I don't think so. I don't believe so. There was a serious lack of DNA on his DNA on core items of evidence as well. So that may be a holdup for the jury. Let me go to you on this right now, Doctor. We have a question from Cynthia Johnson from Twitter. Please explain why Melly is facing the death penalty, yet there's no DNA or gun residue found inside the vehicle. Henry's DNA was found, but he's not facing the might of the law with regards to the death penalty. So why do you think, we have about a minute left, why do you think Melly's facing the death penalty here?
We got 2 deaths, right? We probably got drugs involved. We probably got gangs involved, right? There's so many different things that I think society has kind of condemned as being aggravating factors when it comes to why you can't commit a certain crime. So I think that's probably why he's facing the death penalty.
Now, his defense team will say that they're going after the death penalty because he's such a high-profile defendant. That's one of the reasons they say that law enforcement went after him. They went tunnel vision because he's a high-profile celebrity. Now, the other way to think about this, too, is that this is a case where you only need 8-4 to vote in favor of the death penalty. It's so unique. It used to be you needed a unanimous jury, so the law has changed. It'll be very interesting if he is convicted, what this jury will ultimately decide with respect to his punishment. Well, let me tell you, Bridget Williams, Dr. John Delatorre, thank you both so much for coming on. Really appreciate it. Great analysis. Anjanette Levy is coming on to continue the Q&A. We'll be back.
Oh, man. I really want to get to it. I'm just anxious now to just get to the. I'm looking forward to the defense and to see what their strategy is going forward. Do they decide to bring on their own experts? Well, I feel like they at least need to bring one or the other. They either need to bring some kind of autopsy expert or medical expert, or they need to bring in some type of ballistics, reconstruction, trajectory expert. I think that's a must when we come back from the holiday break and they get a chance to put their case on. I believe that the defense, they're going to have to do that. They're going to have to try to create that doubt with their own experts going forward when they present their case. And then again, you know, I believe the state, if I'm not, I don't know if different states are different, have different rules as it applies to this, but I believe in closing arguments, I'm gonna have to find that out. I don't even want to say that until I do some research on that. But yeah, that's where the case to me is gonna be made. Aside from this, I believe this scientific evidence, the last 3 days of trial, 3 or 4 days, has changed the, you know, the look, the feel, and, you know, the momentum. Because I feel like trials are just like any kind of other sport. You get momentum. And that's kind of what, and we always go back to the OJ, because that was the first big trial most of us had ever got to watch from beginning to conclusion. The state had the momentum early. And the defense kind of took over the momentum once they put on their DNA experts, and they rode that wave all the way until not guilty verdict. So right now I feel like the state has a little bit of momentum. The afternoon session, I believe, will let us know if they're gonna continue with that into this week break. A couple of experts said they believe this break benefits the defense. I have a difference of opinion when it comes to that. I believe that during this break, I think common sense is going to kind of set in. Like, what's your common sense tell you? Or you may get somebody that gets in their fees and feel like, oh, well, I really can't put a man to death. Although I'm sure they were asked all these questions, you know, in their questionnaire or vetting to be a juror. But it'd be interesting to see. I think.
Good afternoon. I'm Anjanette Levy, and thanks for joining us here on Law and Crime for the lunch hour in the trial of YNW Melly. We are taking your questions as we always do this lunch hour, so keep them coming to us on YouTube, Twitter, Facebook, Instagram, TikTok. We'll get to as many of them as we can. Testimony has been underway now for just over 3 weeks. It appears we are nearing the end of the state's case. We want to just give you a quick recap to bring you up to speed as to where we stand in this case. YNW Melly is, of course, the Florida rapper whose legal name is Jamell. He faces 2 counts of first-degree murder for the October 2018 shooting deaths of his 2 friends and YNW members, Christopher Thomas and Anthony Williams. They went by YNW Juvie and YNW Sack Chaser. Melly faces the possibility of the death penalty if he is convicted of those 2 first-degree murder counts. He has a co-conspirator in this case. His name is Cortland Henry. He will be tried separately at a later date, and Henry is actually on house arrest. So he will be back in court tomorrow for a status hearing and on a motion to modify conditions of his release. So we will have that covered for you. We have a great panel for you today. As always, Terry Austin of Law and Crime is down there at the Broward County Courthouse covering the trial for us. Brian Buckmeyer, host here at Law and Crime, is here with me as well, as is Afi Peterson, a lawyer out in the California area. So Terry, let's start with you. What happened in court today?
It was a very interesting morning, Anjanette. We started out having a witness taking out of turn. She was from the Department of Transportation, and she was there for the prosecution just to admit the tape from the highway Department of Transportation had videos of cars. And she got up, she got down, there was no cross-examination, and then she left. And then the prosecutor just played the videos without any sound, without the witness, and without an explanation. So we all sat in the courtroom for about 20 minutes watching videos. And then after that, it turns out they put, you remember Sergeant Christopher Williams, who is the crime scene reconstructionist, they put him back on the stand. There was no further cross. The prosecution went up on redirect, had a couple of questions regarding height and distance, and then he stepped off the stand. So then after that, we just had arguments between the attorneys regarding evidentiary issues. Prosecution wants to get in some Snapchat videos. She wants to show the ownership of those phones. The defense said, look, they're not relevant, they're prejudicial, and so the judge is determining whether or not he should let some of those in and whether or not he should keep a few out. Sounds like he might put some in and keep out ones that have sound. So we're waiting on a decision for that. He may have already told them, but we haven't heard in open court. And then the last issue that happened today was the vehicle, the subject vehicle. It is in this building. The jury may go down and see it. They won't see it today because the judge said he was told it is not yet secure. You have to secure the scene, make sure you can transport everyone downstairs. So if we see it, it will not be today. Right now, the prosecution is going through hundreds of photos to determine which ones might be cumulative. And other than that, that's all that's going on. We're on recess and the jury is out for lunch.
Well, that jury has certainly seen a lot of photographs of the Jeep in question, the one that was involved in this case. It will be interesting for them, I think, to see it up close for their own eyes, like right in front of them. We are taking your questions, as always, so let's get right to it. We have a lot coming in. This one is for you, Brian Buckmeyer. At Pineapple Splash 9166 from YouTube asks, why did Bortland change clothes before he took his friends to the hospital? That's odd in and of itself.
Well, thank you, Pineapple, for that. I agree with you as well. I can't really answer the why. I'm not really in his mind, but I can kind of go through different scenarios. There could be the issue of gunshot residue. Maybe he's worried that that's going to be on his body if he is the shooter or if he had interacted with anyone. There's also an argument that if someone was shot at that close range, whether you're the shooter or you're Cortland, who's considered to be the co-conspirator, blood would have splashed back and hit something or someone. So maybe he's changing his clothes to get rid of the blood. It would be considered what many would say is consciousness of guilt. The only question is it guilt because of association or guilt because of actually being the principal and committing the crime? I don't know.
It does seem strange, though, that if you want to get your friends to the hospital, Brian, I mean, you're a defense attorney. If you want to get your friends to the hospital because you've just been shot at in a drive-by, as that he claimed, I mean, do you really stop and change your clothes?
I don't think so. In my mind, I think as the same with most people, you would rush to the hospital. You would get there as quickly as possible. If it was a situation like, oh, there's blood on his clothes, like, yeah, there's blood on my clothes because the guy behind me shot or someone else shot and I was just a bystander. My mind, I think like everyone else, would just go straight there. But I also think that some people would be like, hey, I'm worried that they would try to implicate me, so maybe change my clothes. And as stupid as that is, I've heard dumber explanations from innocent people before, so I wouldn't put it past someone.
And I think we should remind the audience here, the viewers, that there is surveillance video of Bortland literally running into the hospital. I mean, he's pulling in really fast, and then he's running into the ER to get help for his friends. So the changing of the clothes seems a little odd when you've got that taking place. Tralisha Mornay's of 2141 from YouTube. This one's for you, Afi. She asks, how will the defense combat with the evidence that the state is presenting? Circumstantial evidence is just like physical evidence, right?
Thank you, Tricia. I think yesterday's evidence, the crime scene reconstruction expert, was pretty damning and damaging for the defense. And I think if the way that I saw the defense on cross questioning the expert, who was solid and couldn't really be moved, it was almost acquiescing to the fact that Melly may have been in the vehicle that night. I think the only way that the defense is going to be able to combat that is to put on a reconstruction expert of their own. I think that's the only way that they can rehab their case. And because I think yesterday's expert was just so solid, he just couldn't be shaken even on cross. So, the only way to combat that is to put your own expert on.
Mm-hmm. But the circumstantial evidence is obviously that's kind of like evidence that you didn't see. Like direct evidence is somebody saw this happen. A circumstantial evidence is stuff like DNA, a fingerprint, things like that. So physical evidence can be circumstantial evidence. So I just kind of wanted to add on to that as well. Tammy Blanchard, question: what benefit is it, Terry, to look at a vehicle that has been the scene of the crime? What's it going to prove? Is it to encourage the jury? So what do you think the reasoning is there?
That's an excellent question. And the prosecution is the party who has asked for the jury to go and see the vehicle, partially because they want the jury to understand the size, the distance, whether or not it is possible for someone to shoot from inside the car or outside the car. But I do think that there's some shock value as far as that car is concerned. One of the things the defense argued was, look, Judge, it's not going to be overly prejudicial. It's not fresh blood. It's dried. It's not going to be shocking to that jury. But I've got a feeling that the prosecution wants them to see that car so they can put themselves in the place at the scene of the crime, or at least in that car. And oftentimes I think juries are moved by that. They can understand what's going on. They might be impressed by the fact that, this is where it all happened. So it should benefit the prosecution if the judge allows it to happen. It looks like he's leaning in that direction, but hopefully it'll help the defense as well. I shouldn't say hopefully. I mean, I think it helps both parties, hopefully, for that jury to understand what could actually happen in terms of distance and in terms of height and in terms of trying to figure out what was the trajectory of those bullets.
And it wasn't, this wasn't a big Jeep. I think of Jeeps and, you think there's Cherokees, like the Wagoneers. These are some bigger cars. This is kind of like a smaller model too, Terry.
It is, yes. It's a smaller car, and they had a seat in the courtroom. The reconstructionist actually had a seat so he could show how you can find blood, but that seat, my understanding, is much bigger than the actual seats in that car. So it's going to help the jury to get a feel for what could happen, whether or not Melly's arm or whoever was sitting in the back seat could really actually turn to the right and make a shot to his right, and then also make a shot in the front of that car. So it should be helpful for both sides.
Mm-hmm. Brian, this next question goes to you from Facebook. It's from Dominique Nicole, and she asks, so who did Melly shoot first? Because I'm sure the other isn't just sitting there and let him shoot him without trying to fight back. So who was shot first, Brian?
So, Dominique, thank you for that. I can only speculate. I don't think based on the reconstruction you can say which one of the bullets went through first. And with forensics, you won't be able to say who was shot first between the two bodies because it would be seconds apart, I would assume. But thinking out loud, I would assume it would have to be back seat then front seat. Because if you shot front seat then back seat, by the time you shot the person in the front passenger seat and you turned to the person next to you, I would assume that person would be grabbing your arm and fighting you. But if you shot the person in the back seat first, instinctively the person in the front would turn to face you to see what happened, and then I think you'd have an easier shot there. But that's just speculation.
And it all could have unfolded so quickly and in such a small space. Just hearing that noise, the guns are loud. I mean, you would be stunned, I would think, by that. Our next question comes from Hood Affairs DVD from Twitter. Offie, this is for you. If Melly pointed and shot the victim, why was the hand furthest from his head or face struck first when he was close enough to put the gun to his head? Being hit in the second hand seems like a miss from a further distance. Do you have a theory on that, Offie?
You know, I don't have a theory on that, but I think what's interesting is everybody is saying, well, this is what I would do in this situation, or this is what my friends would do in this situation. But we still don't know who was involved. So you have the driver. Was the driver involved? Did the driver have a gun on anyone and say, hey, stop, whatever? Who knows? We just know what we would have done in that situation, and who would ever normally be in a situation like that. So you really don't know. We can just speculate until the end of time, but I really couldn't call it.
Yeah, I think it just being in the car, if you are in this vehicle, you would be stunned by that. It would be shocking, I would assume, and you wouldn't maybe have much time to react. Our next question, Terry, this one's a good one for you. At Amy_K22 from Twitter, how much of an impact do you think the highway surveillance video will have on the jury?
0. At this point. I mean, unless they put that video back up again and they have someone explaining what the jury is looking at. It was very dark. The vehicles that were on the road were very small. We had no idea what type of vehicle we saw going through those videos. So I don't think the jury is going to make much of that at all. And no one has identified those cars, whether or not it was the second car or the red Mitsubishi. We have no idea. So if the jury was paying attention, and they were, I was in there, they were looking, but they were also looking around as if to say, well, is there something else, prosecution? Are you going to tell us what this is? And that never happened. The witness who made the foundation for the introduction of that video into evidence, she came and she spoke very briefly, probably 5 minutes, and then she left. So I don't think it's going to have much of an impact at all, if any.
Interesting. Brian, for you, Willie Wallace 78 from Twitter. How is the co-defendant on home confinement?
So Willie Wallace, thank you for that question. From my understanding is they both had an arraignment because of the belief, or at least the evidence pointing towards YNW Melly being the shooter. He was remanded, or he did not have an opportunity to post any kind of bail or bond because of the, I guess I wouldn't call the weaknesses in the case, but not the fact that the co-defendant is not perceived to be the shooter. He was afforded bond, but one of the conditions is if he bonded out, he would have to be under home arrest, or house arrest, sorry. And so that's why he's on house arrest and YNW Melly's in his situation.
Yeah, it's a pretty interesting thing that he's on house arrest. He's being monitored. He'll be back in court tomorrow. So it's pretty interesting that that was allowed. Miss Duchess, Florida, FLA, from Twitter asks Afi, they mentioned they will come back on the 10th of July. Is there going to be a break in the trial? If so, why would they be allowed such a long break?
Well, thank you, Miss FLA and Miss Florida. I think there is a break in the trial. I think Friday is the last day. I could be wrong, but Friday until the 10th. It's really the court's discretion, but I do believe the judge has something that he has to attend. I don't know if it's some sort of judges conference or something that he simply can't get out of. And I think we have the holiday coming up as well. So it really is the court's discretion. A lot of times the court will reach out to the jurors and see if that's acceptable for them, because this is an extended trial. It's challenging for a lot of people to be out of work for 3 weeks, 4 weeks. So a lot of times, of course, it's the court's discretion. The court will check in with the jury, but if there is something that the judge absolutely cannot get out of, you'll see gaps like this in the trial. And you'll also see the court is going to give the jury instructions on what to do, what not to do while they are on this large break.
And, this does happen sometimes. We've seen it happen in other trials where there's a break. And we do have the July 4th holiday coming up next Tuesday, plus court is dark on Fridays. So that's 2 days right there. You wouldn't be in court. And a lot of places, it's my understanding, are also closed on the 3rd for that holiday. So you'd have maybe 1 or 2 court days next week. So typically the judge, if they had something going on, they would mention that in voir dire, and that would be a part of, asking the jurors about their availability, etc. We're going to take a quick break. Keep those great questions coming to us on Facebook, YouTube, TikTok, Instagram, and Twitter. We'll get to as many of them as we can, but we're going to take a quick break. Stay with us. I'm Anjanette Levy, and you are watching The Lunch Show.
Let me see what's going on in the world. The Supreme Court strikes down affirmative action programs in college admissions. Nicki Minaj got a new album coming out. Pink Friday 2. Okay, Queen. Okay. Let's see what else. Jonathan Majors files complaint against Grace Jabari with the New York Police Department ahead of his trial for assault and harassment. Ooh, they on that boy top, ain't he? Hey, I watched Creed a couple weeks ago. It wasn't all that to me. It was alright. It could have been better, I thought. Maybe we just over the whole Rocky scenario. I don't know. Let's see what they talking about.
Has fired multiple deputies, and no one will say how many deputies, after these 2 black men filed this lawsuit. And they said, of course, they were tortured for nearly 2 hours. But get some of these details here. They, after filing this $400 million lawsuit, they allege that not only were they handcuffed, kicked, and waterboarded inside this own home, okay? And tasers were used on them several times. And at one point, the men claimed that the deputies pulled out a sex toy and tried to sexually assault the men inside this home. And then one of the deputies pulled a gun and put it into one of the men's mouth, opened fire. Take a look here now. The Reagan County Sheriff's Office in Mississippi has fired multiple deputies, and no one will say how many deputies.
Whoa. Hey, I have a friend of mine.
Can't stop, won't stop the Kia Boys.
200 car thefts, 300 car thefts.
They've been wreaking havoc in almost every major city in the United States, stealing cars, mostly Kias and Hyundais, for clout and teaching others how to do it on TikTok.
So it's going to be over $3,000 just to get my car.
And now these companies have to pay up.
Shame on Kia Hyundai.
The $200 million settlement and what you need to do to get a piece of it. I'm Justin Carter. TSR News starts right now. If you own a Kia or a Hyundai between the model years of 2011 and 2022, and it was recently damaged or stolen, pay attention and get ready. In December 2022, attorneys filed a class action lawsuit against both Hyundai and Kia, and in May 2023, they settled for $200 million. It opened up what's being called welcome relief for people who purchase these faulty, easy-to-steal cars from these companies. Caught on camera in Milwaukee.
I'm gonna call the police.
They tried it in Minnesota.
This is my car, and I am calling the police.
And this woman in Detroit begging a car thief not to take her car.
Please, please, please don't take it, please, sir. Please don't take it. Thank you.
I woke up on Sunday morning and my car was gone.
Oh my God. He's been.
And thanks for joining us here on Law and Crime. We are taking your questions this lunch hour in the YNW Melly double murder trial. So keep them coming to us on Facebook, YouTube, Twitter, Instagram, and TikTok. We'll get to as many of them as we can. And speaking of TikTok, we've got a question coming in from TikTok. It's from Melly Lover 2.0, who asks, and I'll send this one to you, Afi. If Melly gets locked up for any time, will the 4 years already count toward his sentence?
Oh, so thank you, Melly Lover. Usually, when you don't have a bond, when you're remanded into custody, if you are convicted or if you plead guilty, you will get something that's called credit for time served, and the judge will usually say it on the record. So if he is not sentenced to the death penalty, if he gets a certain number of years, he will get the credit for the time that he served toward anything that he's sentenced.
Yeah, but if he gets convicted of first-degree murder, I mean, the likelihood of him ever getting out is pretty slim.
Right.
Yeah, I mean, so, yeah, he would definitely get credit, but he would be in there for a long time. Amarisi Bree from YouTube asks, Terry, will this be a hung jury for Melly? Barely any evidence toward him, according to Amarisi Bree.
Okay, Anne-Marie Spree, that's an excellent question. I think because the evidence right now is not definitive, I don't think the prosecution has proven anything beyond a reasonable doubt, and they are aware, the jury is, that this is a death penalty case. During voir dire, they were asked those questions. So I think a jury is going to be very careful to determine whether or not he is guilty with the evidence they've seen so far. So it is possible that we could get a mistrial. There might be some jurors back there who think that this is enough evidence, who think that it's possible that he did it, and that there is very little doubt. But I think there might be other individuals back in that room when they're deliberating saying, look, this is not beyond a reasonable doubt. You might be putting someone to death who hasn't been, shown that he absolutely positively did it. So we could very well get a mistrial. It's an excellent question. Right now, if they had to go back and deliberate, I would say that's a big possibility. We haven't yet seen the defense case, though. So, we could get an acquittal if the defense case is that strong. So still more to be seen.
Yeah, still a lot more to come. We are not even in the defense case yet. So, and it only takes one juror for a hung jury. So Rose Sadler from YouTube, Brian, has there been even the slightest hint of a motive? Nobody just leaves a studio in the middle of the night and decides, hey, I'm going to kill my best friends on the way home.
So far, and thank you for that question, and I'm waiting for the same thing too. I haven't seen a motive here. Now, let me be clear. There is no element that is motive in any of these charges. The prosecution doesn't need to prove a motive in order to get a conviction. But in a case like this, where there's so much circumstantial evidence, you're asking jurors to take a logical leap in many regards. Not having a motive can be detrimental to the prosecution, but very helpful to the defense. And in a case like this, even more so, where you're like, wait a second, they're walking out of a recording studio. YNW Melly is a part of this group, this gang, whatever you want to call them, but not just from like an association, but from a business standpoint. He's messing with his own money. He's messing with his own friends. He's close with these people. Why would it go this direction? Now, of course, we've heard rumors from the family as to why it may happen, but while those may be true, they're not in front of the jury. So as far as the jury knows, this doesn't make sense, and that might lead to a hung or an acquittal.
It'll be interesting to see if the prosecutor in this case, Brian, kind of offers something in closing when she ties this together. I don't know if she will, but we shall see. Julius Czar from YouTube asks, will the defense have to prove that Melly got out of the vehicle at some point to go with the theory that he wasn't there? Afi, what do you make of that?
Okay, so thank you, Julius. That's a great question. The defense does not have the burden to prove anything. Of course, that burden is on the prosecution. But I do think that they need to craft a story somehow for the jurors, because I doubt Melly is going to testify. So I think what we've seen throughout the last few days, especially with the most recent experts, is that everybody sort of says, well, what would I do in this situation? So we all know that Melly left the studio with Sack, with Bortland, and with Juvie in the vehicle. We all saw that. And then the next thing we know is there was an alleged drive-by shooting, and we see Bortland taking these two gentlemen to the hospital. So what happened in the in-between? What is logical? Who is going to get out of the car at 3:50, 4 o'clock in the morning? For what reason? So I think that the defense definitely has to shape the remainder of their questioning, if they can, and show that it's plausible that he got out of the car, or that this was some type of execution style killing where if he was in the car, he really, couldn't move, couldn't do anything. He was a victim, just like these other gentlemen were victims, excuse me.
Terry, our next question comes from @cbrad742 from Twitter. @cbrad742 asks, was gun residue found on Melly?
There was no gun residue found on Melly. Excellent question. You would think that if he's inside that car, he would have some gun residue. It is an issue of when that was swabbed and how long it took for them to get it. So one of the issues on the stand with Sergeant Christopher Williams was it wasn't tested for a while afterwards, and there were 3 substances, iron and I think copper and another substance, and they found some but not all, so they couldn't definitively say that there was any gun residue on Melly. And I think that helps the defense, the fact that his DNA only appears in one place, in that back seat on the door handle behind the driver, that there's no gun residue on him at any point in time. So all of those things I think will help the defense ultimately when they have their closing arguments. Believe me, those are things they're going to point out. So excellent question.
Brian, this is a Twitter question from @TLeah was the casing or bullet found in the back seat of the same caliber as the ones found on the road?
And please correct me if I'm wrong, great question. I think it is. I think they're all the same gun. I don't think there's been any testimony to the effect that there may have been a second gun that was discharging bullets. I think it's all one gun. Bullets coming from that one gun.
Yeah, 40 caliber rounds is what they were. Some type of Smith & Wesson, I think, is what the head stamp said. Let's go to this next one. Jessica Ann from Facebook. Afi, with all of the sidebars and breaks, do you think that it is having an effect on the jury? Will the jury be able to look past it during deliberations?
Well, thank you for the question. I think they'll have to look past it during deliberations. And I think, frankly, it's something that they've gotten used to. I think early on it was quite exhausting, but now it seems like it's sort of par for the course. And the thing is, jurors, a lot of them don't really have any type of connection with the criminal justice system. So they're going to take a lot of their cues from the judge. The judge is the person who is directing them with the most authority. So I think that they're going to rely on reading the judge, reading the judge's mood, and reading the judge's decisions to kind of take a temperature for who they should rely on most, what they should do most, and who they should trust.
Terry, this is a really interesting question, and this goes to the fact that firing a gun anywhere let alone in a vehicle, would be incredibly loud. Kay Lancaster from Facebook asks, did the doctors check Cortland's hearing? Because a gun being fired inside a car multiple times, wouldn't you think it would cause temporary hearing loss?
Another excellent question. There is no evidence at this point in time that his hearing was checked, but we did hear from Sergeant Christopher Williams, and he did say it would have been very loud. It was on cross-examination where he mentioned that. So anyone in that car not only might have gun residue on them, but they would also hear it and be surprised or shocked by it. And one of the things that Williams said was he thought that Christopher Thomas, who was in the back seat, had his hand up and the bullet shot through his hand and hit his cheek, and that was the bullet that killed him. And then he thought, because of the sound, that perhaps Anthony Williams in the front seat might have turned, and that's how we got that shot in the head. But he did state, as a reconstructionist, that it would have had to have been extremely loud. But to this point, there hasn't been any evidence that anyone's hearing was tested.
Anna Dotson from Facebook, Brian, wouldn't there be some kind of blockage in the blood spatter on the door if someone was sitting in the seat?
That is a great question. I think that's something that either side should either focus on or try to push to the side. And I'm hoping I'm understanding your correction right. It's almost like the Looney Tunes thing where something explodes in front of them and then there's kind of like a cardboard cutout of them behind them. I think it would be the same thing with the blood. If this is truly someone who's shooting from the back driver's seat and you shoot the person next to you and the blood splatters, spatters, not splatter, blood spatters, there should be some sort of etching out of where they're sitting. There should be a lack of blood hitting a certain area based on the person's body and torso. I think that would give a lot of information. I'm wondering if anyone's going to point that out when they go and look at the vehicle.
Yeah, it's an interesting question for sure. All right, we're going to take another quick break. Stay with us. Keep the questions coming on YouTube, Twitter, Facebook, Instagram, and TikTok. We'll get to as many of them as we can. I'm Anjanette Levy, and you're watching Law and Crime. We'll be right back.
So yesterday I said something about them bringing up the wreckage, but they ain't found no remains. Well, I guess they found some, tangled within. Let's see. The evidence will provide investigators from several international jurisdictions with critical insights into the cause of this tragedy. There is still a substantial amount of work to be done to understand the factors that led to the catastrophic loss of the Titan and help ensure a similar tragedy does not occur again. All right. That's what they got going on. Let's see what else. Okay, Kodak Black. I believe he had to turn himself in because he failed to provide urine analysis or something like that. Yeah, failed to. Okay, so he out. Big Zoe. Madonna was rushed to the hospital after being found unresponsive. Her manager previously revealed the singer had developed a serious bacterial infection, which led to a several-day stay in the ICU. Ooh. Damn, Madonna, you gotta get it together, girl. You gotta get it together. Like a virgin. Not for the very first. Okay, maybe not. Maybe not. I like Cyndi Lauper a lot more than from that era. I was a Cyndi Lauper kind of guy. From that era, Cyndi Lauper, who still looks amazing. Cyndi Lauper, shout out to Cyndi Lauper. Girls just want to have fun. That was the jam. That was the jam. There they go. Let me see what Let's see what's going on TM Zizzle.
Welcome back. I'm Anjanette Levy, and thanks for being with us this lunch hour in the trial of YNW Melly. It appears that the state is nearing the end of its case, and maybe the defense case will start very soon. So we're still waiting to hear on that after the lunch break. In the meantime, we are taking your questions about this double murder case. So keep them coming on YouTube, Facebook, Instagram, TikTok, and Twitter, and we'll get to as many of them as we can. There have been some really good questions so far today. If you haven't been following the trial very closely, we'll just recap really quickly that Melly is accused of murdering his two friends, Chris Thomas Jr. and Anthony Williams, back in October of 2018. He has a co-conspirator who was driving the vehicle that night. His name is Cortland Henry. He has pleaded not guilty and will be tried at a later date. He'll also be in court tomorrow for a status hearing and a motion to modify bonds of his release. He's on house arrest right now, so we will have that covered for you as well. Our next question is from badlands.ant. Offie. This is from Instagram. Does the sergeant's testimony prove Melly was inside in the car or the shooter? How does this help the state's case?
All right. Thank you, Badlands. I don't think anyone's testimony thus far has proven that Melly was in the vehicle or the shooter. I don't think anything has gone toward benefiting the state's case. In that matter, I think the defense has done everything they can to poke holes in the idea that Melly was certainly not the shooter, or that he was even there in the vehicle that night. So I don't think that's been done by not the sergeant, not anyone yet.
Mm-hmm. Terry, how did you feel the Sergeant Williams' testimony was received in the courtroom?
I thought Sergeant Williams was really good, and primarily for the prosecution. I think defense did a good job trying to cross-examine him, but he is very familiar with what is going on, and he really wasn't allowing too much to happen. Each and every time defense counsel tried to say, well, couldn't this be a possibility? He kept going back to, no, that's not a possibility. I looked at all the possibilities, and it isn't conceivable, because he kept saying the blood spatter wasn't possible based on what he saw to be outside of that car from where that shooting occurred. And he also said that he did not think, based on the trajectory of the bullet, that it was possible that anything else could have happened except that it was from the back seat on the driver's side. So I thought he was very effective. He was funny. He had a good rapport with actually both prosecution and defense. I think the jury looked at him and believed what he had to say. So not many points were made on defense side, but there still isn't, and we've all been saying this, there still isn't any direct evidence or circumstantial really to say it was Melly holding that gun doing the shooting.
Let's get to the next question. HP Heart, it's a blue heart from YouTube. Was there blood found on the outside of the car door handle where Melly was sitting, Brian?
Well, again, correct me if I'm wrong, but I haven't heard of any testimony to that effect, that there was no blood on the outside of the door. I would assume what you're thinking about is maybe Melly does the shooting, gets blood on him, leaves the door, leaves out the door, either opening from the inside or reaching to the outside, and then closes behind him. No, but that actually makes me think of something else. If he shot the gun and blood goes everywhere, there's a good chance that there's blood on his hands. And while it is very TV or movie-esque that fingerprints are all over the place, there's a higher chance of leaving a fingerprint if you have a substance on your hand, like blood. So it would be curious to me if there's any blood, handprints, or fingerprints anywhere. I haven't heard of that yet. That might lean more towards helping the defense.
Yeah, the only thing we've heard of is this DNA on the inside of the vehicle, on that, driver's side passenger door that they swabbed for just recently and found. OE Ghosts from YouTube asks, Afi, do you think Bortland will testify?
Thank you, OE Ghost. I do not think that he will testify. He has a right against self-incrimination. He's also being charged with murder, so I very much so doubt that he'll testify. But I think what's really important to the jurors and to the audience is that there were 5 people there that night. So there was Portland, and then there were the 4 other people who were in the vehicle that were leaving the studio next to Melly and Juvie, Zach, and Portland. So why are they not testifying? I'm sure, people want to see evidence from them. They want to hear from them. They want to know, what was the agenda when you left the studio? Did you hear from them? Do you know anything about any beef that was going on? They could illuminate so much. And so I think a lot of people are wondering, why aren't we hearing from them? And what does that absence say about, thus far, the plaintiff's case? Excuse me, not the plaintiff, but the prosecution's case. And what will it say about the defense's case?
Yeah, it would be interesting to hear from the people in the other vehicle. And we've heard their names, but we certainly haven't heard from any of them. Let's see, MF_Sneezy. This is from TikTok, Terry. Have they found the firearm that was used in the crime?
They have not found the firearm that was used in the crime. They've speculated what it could have been based on the casings that they found, but so far no gun. They think that it's a type of Smith & Wesson, that it's a .40 caliber gun, but they don't have the gun itself. So it has been argued that pictures of Melly with guns in either his Snapchat or any other social media should not come in, and so far the judge has been keeping those out. But we haven't connected a gun to Melly or any of the other individuals as of yet. And at this point, I doubt very seriously if they will locate the gun associated with these shootings.
Yeah, if they haven't found it by now, they're likely not going to ever find it. Sarah Fitzhugh from YouTube, Brian, asks, how do they know that neither Zach nor Juvie didn't shoot at each other or vice versa?
Well, thank you for that question. I think it's based on the bullet trajectory, but that's all depending on who's sitting where. If you're keeping everyone in the same position as what they went into the vehicle, which is what the prosecution is believing, then the trajectory of the bullets must be from behind the from right here where we're looking at the driver's seat behind them. And so they're saying based on the trajectory, that's must where it's been. But if there's a shooting going on in a car, I don't think everyone's just sitting where they are. There could be people moving around. There could be a fighting for the gun. I mean, it could just be as reasonable that whoever's sitting next to YNW Melly pulls out a gun, he starts wrestling with the gun, and as they're wrestling for it, it goes off and hits the front person, and then as they're wrestling, it goes off and hits the guy who actually had the gun. That could happen, I don't know. But I don't think there's been any definitive answers other than it came from this seat in this direction going this way.
And really, Brian, that's my question. If they're saying, this guy can say, look, I did all these measurements, I did this, here's where this shot came from, then who else is sitting in that seat? The only person we know of that night sitting there was Melly.
Well, so this is, if I'm the defense attorney, this is the argument that I would make. Imagine myself and the jury are sitting in the front of a home. We can see the front entrance, but we cannot see the back of the house or how anyone can leave the back of the house and just go. If we see YNW Melly walk into the house, and then 6 hours later we find out someone died in that house, and YNW Melly's not there, yeah, one reasonable explanation is that he walked in the house and killed the person. Another reasonable explanation is whoever was in the house before we started watching the house could have killed them. YNW Melly could have left through the back door minutes before he got there, and then in the next 4.5 hours, someone could have come in through the back door and murdered someone. I don't know, but all those explanations are reasonable, and if they create doubt, then that's what's called reasonable doubt. Melly could have left the car and someone could have come in. He could have been there when the shooting. The gun could have shot from that direction, but from someone else. I'm just giving out hypotheticals that are reasonable, and that's all the defense has to do.
Yeah, we'll see what the jury has to say about it. It'll be up to them to determine, the truth in this case. We're taking a quick break. More questions to come afterwards, so stay with us. I'm Anjanette Levy, and you're watching Law and Crime.
Another quick break. We still have another half hour or so before court resumes. So I'm going to continue my little expose around the internet. We already saw this. Ooh, this boy Kevin Costner. I remember a long time ago, in Pasadena, where I'm from, California, he had a restaurant, and I think he had to give that restaurant to his wife at the time. So he stayed giving up stuff, and maybe he shouldn't get married anymore. No, they proved it was her. It was her. She actually said it was her account. If you remember when the girlfriend's mom got on the stand, she kind of like just slid it in the beginning, like, "Do you have social media?" And then she asked her what the lady responded by saying what kind, and she was like, "Yeah, I have Instagram." And she was like, "Well, what's your social media handle?" And she gave it to her. And it was all a setup to get her to, admit that that was her account. And then subsequently, they went to recess. And when they came back from recess, they presented her with these statements in the DMs. And she responded by saying she didn't recall them. She never denied it. She never said no. I think it was like some talk of perjury or something like that at the time. So it's definitely in the evidence. And again, remember, everything that's entered into evidence, the jury can take into deliberations with them. So that includes those DMs. A lot of people forgetting about some of the stuff that was in the beginning that seemed inconsequential, but at the end, it's going to make a big difference. It's going to make a huge difference in the end. Trust me. When they tie everything together and the jury goes back there and then they, start putting the pieces of, okay, this fits, this doesn't fit, this may fit, this ain't credible, this witness was credible. That's how they're going to go through those deliberations. Witness by witness, hopefully. Evidence, piece of evidence by piece of evidence. So, yeah, that was entered in the evidence, those DMs. Where she clearly said, everybody else is living it up. I quit my job, or I don't know if she said I quit my job, or I lost my job, or I had to give up my job, and I ain't seen any money. And I think, remember at the end it said Miss Snitch Bitch or something at the end, and yeah. Yeah, she can go to jail. I think she had an ankle monitor. I think she already been in jail over this once for refusing to testify. So, and then also, oh, we
Back. I'm Anjanette Levy, and you're watching Law and Crime. We are nearing the end of the lunch hour in the trial of YNW Melly, so we are taking more of your questions, as we always do during the lunch hour. Terry, there was something we were talking about during the break. You kind of wanted to clarify something about the people who left the recording studio that night in October of 2018 that were in the red vehicle next to the SUV that Melly and his friends were in. So tell us a little bit about some of the people in that vehicle and why we're not hearing from them during the trial.
Well, that's interesting. Everyone keeps talking about Melly's vehicle, but if you recall from that video, there were two cars, Melly's vehicle, or the vehicle Melly was in, I should say, and also a red Mitsubishi. And what the prosecution said on her opening statement, she basically listed the names, and I'll look at it so I can get it correct. Trevion Glass, Dentambius Withers, Jacoby Mills, and Adrian Davis. They were in that red Mitsubishi. Now, Trevion Glass is a witness that was on the list for the prosecution, and they subpoenaed this individual, but because he is located outside of the state, he can decline to come, and he has declined to come thus far. So we got a subpoena from the defense counsel, and they wanted to depose this individual because the fact that prosecution wanted to call him. So at the end of the day, nothing happened. There was no deposition as yet, but tomorrow he is supposed to come to appear, but no one is thinking, not the judge, not the prosecution, not the defense, no one is thinking that he's going to appear. He doesn't have to by law, and he has indicated to the prosecutor that he's afraid for his life, and so he doesn't want to come. And it does appear that all of the parties have accepted that fact. They're going to, I think, show up tomorrow. Interestingly enough, the prosecutor had a conflict, and the judge basically said, clear your schedule. If you have a problem clearing your schedule, just talk to me and I'll talk to the other judges, and just show up and we'll see if he shows up. So tomorrow morning, we'll see whether or not Trevion Glass actually comes. No one's expecting it, though.
Yeah. We do know that if he doesn't show up, we know who will be in court tomorrow, and that's Cortland Henry, YNW Bortland. He has a status hearing. We'll have that covered for you. Next question is from Pink Panther Tees from YouTube. Question, what would happen to Bortland if Melly is found innocent, Brian?
So it's what I would call like a legal fallacy. I understand that many people have been asking this question. It's like, well, if he's acquitted and he's considered to be the shooter, then how are you prosecuting someone for conspiracy of that crime when this person is acquitted? Again, it's a legal fallacy. You can still continue with that theory. You can prosecute someone for aiding and abetting, even though someone is found not guilty of that crime. Just the way that if 4 people in a car and a gun is under the seat, you can prosecute all of them for possessing a gun, even though it's hard, if not impossible, for 4 people to possess one gun.
Our next question, Afi, Apple Boss. If he wasn't at the crime scene, how does Melly know it was a drive-by, as everyone keeps claiming?
So thank you, Apple Boss. And I think we got that information from his, we kind of got it in from his girlfriend's mother, because on the night of the shooting, I believe he made a call to his girlfriend, and the mother stated that she was there and she heard the call, and Melly said that he was, I guess he intimated that he was in a drive-by. The girlfriend was alarmed. I think she was hollering and just relayed information to her mom. He was, I think, I think I recall some testimony about him being maybe in the bushes and bloody. I'm not sure, but I believe that came out a little bit early on with the mother's witness testimony, that he was definitely somehow related or had knowledge of the alleged drive-by.
Mm-hmm. Our next question comes from free._Melly from TikTok, Terry. If Bortland is found guilty and Melly is not, or for say they are both found guilty, will Bortland get the death penalty?
Well, they haven't asked for the death penalty for Bortland, and I suppose they have to give notice and they could change. But as of right now, they have already charged him with the murders, and his case has been severed from Melly's case. If Melly is acquitted, like Brian previously stated, they can still continue to pursue Bortland Henry, but they will have to certainly change their theory as to where those gunshots came from. But I think if both of them are acquitted, then obviously nobody's going to get the death penalty. So it's an interesting situation here, I think, when you have these two defendants and they are trying to literally point the finger at each other.
Brian, this one's a pretty easy one for you as a defense attorney. Carrie Treenan from YouTube, how many jurors does it take to reach not guilty? And we have just about a minute left.
Oh, it's got to be unanimous. All jurors, whether it's a 6-jury panel or a 12-jury panel, need to be unanimous to find that they're not guilty. If it's 50-50, 10-2, whatever, that's typically a hung jury. And on the opposite side, in order for guilt, it also needs to be unanimous.
Yeah, always with a criminal case, it has to be a unanimous verdict. It's different sometimes in these civil cases. We'll do one more question. Afi, literally we have about 20 seconds. Sammy Brown from YouTube, why is a case like this getting the death penalty if a school shooter gets life?
Fantastic question, and usually it's up to the prosecution. And for in this case, it's because of the alleged egregiousness of the case. It was an execution-style shooting. So it's just the nature of the case, the violence of the case. But again, it's up to the prosecution and what they want to pursue.
And what the jury comes back with in their recommendation. All right, thanks, Afi. Thank you, Brian. Terry, we're going to let you get back into the courtroom. I'm Anjanette Levy. Thanks for being with us this lunch hour. We'll be right back.
Oh, man. So 1090 Jake just dropped a video. Let me see if I can look it up real quick. .1090 Jake just dropped this video. Right? And it's called Young Thug Accused of Snitching. Allegedly gave info. Like, this is clickbait. Like, I don't like 1090 Jake. I'm actually need to take my subscription back. He's lame. Because he made this video and I went and watched it. I definitely went and watched it. But it's clickbait. Because you watch the whole video and he outlines something about Young Thug spoke with a Detective Quinn, such and such, and this and that and the third. And then at the end of the video, he says, I don't believe Young Thug is a snitch. Well, why would you even put a video up there like that? You know what I mean? Like, just to plant a seed? Like, that makes no sense to me. Excuse the background noise, y'all. Thursday is landscaping day. Not just for me, but in my neighborhood, so.
Let me see if I can find. Here we go. Here we go, chat.
Yeah, that. You know what I mean? So in public, try to play crazy, but in private, so man, let me cook. Like let me cook this curry. Hey, man, I'm sure. Let me cook this curry. You know, fuck. I'd rather motherfuckers say like, man, you know what, man? I don't really like this Looks like and run some whole crazy shit for real, bro. Any celebrities on type of shit, no.
Not assume the balance of them is not going to contain information that may have a 403 objection. So we first want to see them all and not be ambushed and try to unring the bell after.
You haven't seen them?
We haven't seen the ones, we haven't had them identify the ones that they intend to play. I mean, if you download some social media with millions of items of information and then come in here and cherry pick some to show, we need to see what they intend to play so that we can have some basis to either interpose an objection or not.
That's what they call a motion in limine. You file a motion beforehand and say, Judge, we need some determination as to all of these videos, which ones they're using or something along those lines, so we're not sitting in here while the jury's sitting in the jury room saying, what are they doing out there?
The other reason for the rules of evidence and the need for authentication is before they admit it into evidence, at the time they establish its relevance. So this is the time for that. Not us asking, looking at 16 million items and saying, out of these, we are going to ask you to eliminate 14. The proponent of the evidence is the one that carries the burden of establishing the relevance of the evidence they propose to admit. And at that time, the relevancy or 403 objection becomes ripe because of what is ensued in the trial and what is left to be proven. And that is our position, Your Honor. And it seems that they only have maybe 8 more and they're a second apiece. I'm not quite sure what the prejudice would be to having them go through them so that the court can see what it is.
So it's clear for the record, Your Honor, that is all the videos on Snapchat. That's the entire production that was sent in. So we're not cherry picking in any way, shape, or form on this particular exhibit.
So how many are there?
There's 5 more, Judge. So that was sent to 2 different individuals that then are these responses they're showing on the screen now, Your Honor. That there is a message that was sent from the defendant. It was a reply. That was a post that he had put on November 22nd, 2018. Then through the 3 messages on items 5, 6, and 7 are responses indicating that Mr. Demmons had posted that specific message online and acknowledging it that they had seen it as one of his stories at that point.
Your Honor, the state just represented initially that they were putting on this evidence to establish the owner of the phone. We then recognized that to have been a pretext because now the state is claiming that the purpose for those highly prejudicial videos is to show that they were sent to a witness. When asked to prove that, the state is demonstrating that it was posted online and somebody responded to it, which is not what the state said. It doesn't show it's being sent to a witness, and it's not for the purpose of establishing its phone, that it's his phone, and it contains lyrics that are prejudicial, and we object on 403 grounds.
Judge, we can always play it without the sound if that's what defense is concerned on, and it still shows that it is his.
You're saying, though, the messages reflect that there's a threat?
It does, Your Honor, and I think that is relevant, and based on the time frame of when it was posted after the homicides, that it is something that should go before the jury. But Your Honor, if Your Honor is going to make the balancing call on that with regards to if the audio portion is considered too inflammatory, the video portion can be played without any audio.
So what do you need the Snapchat account for?
So in terms of the information's already been identified as Melly, Montana, as belonging to the defendant. And if you go on down here, this particular message, which is authored by the defendant, sent to Ms. Hamilton, saying that the individual known as Port, also known as Portland, saved in the phone, which is this co-defendant Cortland Henry, says that he saved the life of Mr. Demmons, and he's coming everywhere with him because if the crackers come grab him, it's my fault. That is November 9th of 2018. In addition, the Melly.Montana name links back to the Celebrate, which also helps show and support that the phone in state 64 belongs to the defendant.
With respect to the statement itself coming in, our position would be that there is no contextual reference of what it refers to. These people have known each other for a long time. Outside of that, if that is what they're using as the predicate for needing the Facebook account in evidence and the court deems it to be relevant, the state has offered to play it without prejudicial audio, and we think that would be an acceptable compromise.
Thank you. Any other, anything else contained in the Snapchat that has, that you're alleging as threats against witnesses? Because I haven't heard anything about a threat to a witness.
No other words.
Pardon me?
No other of those, no.
All right, so regarding what counsel is objecting to, the audio portion of those three Snapchats, I agree with it. On a 403 analysis, take it out. So how long did these run?
Those would take about 10 minutes, and then the state would be intending to publish the 300 photos that we previously identified and showed.
Show the counsel with 300 photos?
Yes, they were the ones that we previously shown. And so in terms of, to make it clear which ones are published for the record, we can put this in to explain the thumbnails and then identify them as by the image number on that, as opposed to putting the entire file name for each image in.
So there was a lot for the judge to determine and take in this morning, as I am now joined by criminal defense attorney Jeffrey Wolf and entertainment attorney Mitra Ahurian. And Jeffrey, let's start with you here. The state is trying to prove ownership of the Snapchat account, but the defense says it's irrelevant. Where do you stand?
Well, I mean, obviously I stand with the defense. That's where I sit most days. But what I will tell you is the reason that they're fighting all of this is because the phone in a criminal case is the whole case nowadays. And so they're going to fight tooth and nail against every piece of evidence that could make their client look bad, that could tie their client to this potential message, which is where this is all heading, where they're saying that he admits that he did it, right? That's what they promised in opening, and that's where they're headed with all of this evidence. And so that's why the phone is so important to them, is because that message was sent from this phone. That's our assumption at this point. And so what I will say is that the defense is doing the right thing. They're making the correct arguments. They're refusing to let the judge stop them from making a record on issues that he's already made up his mind on, because you do have a right to make a record in every case. But what we're really seeing here is what has to be the most frustrating part of any judge's job is when you're sitting and looking at voluminous amounts of data and discovery, and then the prosecution is coming in and saying they should have been able to figure out which 10, 15 videos we wanted to bring in from the thousands of videos in anyone's social media account. It's frustrating for a judge to not have that issue litigated pre-trial, and I get that. And the best practice is to file these motions in limine, which are motions filed about evidentiary issues pre-trial that the judge is wishing the defense had done, and quite frankly, I do as well, because then they could have had these arguments at a time where the judge had the patience for them. The judge should always have the patience to deal with the criminal rights of a defendant in a criminal case, but they don't. And you have to know that as a defense attorney, and you have to litigate these issues pre-trial, because it is clear that if they had done that, they would be dealing with a lot less of the arguments about what the prosecution has or has not given them, what information the prosecution has or has not made available to them as far as exhibits that would come in at trial. These are pre-trial motions in limine issues. They're still appropriately brought right now, but they're most effectively brought before the trial starts. And like the judge said, a jury's waiting in the back.
Well, Mitra, the state says there is a message of threat on these messages. Do you think it should be admitted?
You know, I think that that would be highly prejudicial for the same reason that we are, not seeing his rap lyrics and things like that coming in. This type of content is really consistent with his persona and the, sort of the impression that he gives his fans. So any of that coming in, I would agree, is highly prejudicial. And I think that you're seeing sort of an acknowledgement of that with the compromise that was suggested of, okay, well, we can hear this, we can watch this without audio. So I thought that was interesting.
Well, Jeffrey, indeed, if this would all be introduced in front of the jury, is it all prejudicial?
Yeah, it absolutely is. The bottom line is that this is a tack we're seeing prosecutors take with prosecution of hip hop artists throughout our country. We're seeing it a lot. They want to use the lyrics against them. They want to use the persona they've created against them. But in reality, how is this any different than if John Travolta was charged with a crime, so they decided to show what Vincent Vega did in Pulp Fiction? That is what is going on with these hip-hop personas, and that is what rap lyrics most often are nowadays. There used to be a time when you listened to Notorious B.I.G. or Jay-Z that you were listening to them tell the story of their lives. You're no longer getting that in rap music 99% of the time, and prosecutors should know that, and if they don't know that, it's time for the defense to educate them on that.
Well, it seems that they're trying to sort through what could come in for the jury to see. We're going to see if they're going to come back from their lunch break in just a moment, but when we do, Day 11 continues on the Melly trial. We're coming right back. Stay with us.
All right. They'll be back. Man, I'm checking out this video of like Kodak Black. I think I'm gonna have to do something for that after I get off of here. Post that on my page. It's crazy. I would show it now with that kind of. If you miss any of the trial, man, we've been covering it at least since day 4 for sure. I've been watching from the beginning. It was about day 2 or 3 where I decided I'm gonna follow this whole trial. It was actually Boosie. I watched Boosie post on Instagram say, "Man, I ain't missing no more big hip hop trials." And I said, "He right. Let me go." Because I don't want to hear about it. Secondhand. Since I'm able to. I said, let me go ahead and watch it along with some of my people. So I can see how they feel about it. And at times, you know, they say the wheels of justice churn slow. I think that's how it goes. And in this case, and I'm sure with many trials, it can be, you know, redundant. It can be exasperating at times, or just straight up boring. But you're always looking. As soon as you're not watching, that's when, you know, these little jewels happen, these little moments. For example, yesterday we had a moment where Sergeant Williams was discussing the reconstruction of the crime scene, and defense counsel said, if I had a weapon and I tell you to freeze, you're gonna freeze. And Sergeant Williams' response was, well, I was a beat cop, and I told plenty of people to freeze, and they kept running. And that little moment of silence after his response, defense counsel was just kind of like, he was quiet. Then he was like, I'll give you that. He said that quite often yesterday. I'll give you that. And it's kind of like you conceding to the witness. So it's interesting to see, again, how that plays with the jury. So, you know, I've been devoting all my time to this trial and studying and researching, and I went and watched the YNW Bortland, or listened to, that is, the YNW Bortland audio of his interrogation at the hospital. So, I mean, I don't know what the jury is going to do. You know, from where I sit and how I feel. And as we discussed numerous times today already, we get to see a lot that the jury doesn't. It's without a doubt that if he is not the actual perpetrator, he knows more.
Welcome back to Law and Crime. Our coverage continues in Broward County, Florida, for the trial of rapper YNW Melly. While we wait for court to return from their lunch break, we are recapping earlier testimony from today right now. And earlier, the state called a witness out of order, and that was financial investigator Tashawn Newman. She testified for less than 5 minutes. Let's take a listen.
Good morning.
Can you say your name and where you're currently employed?
My name is Tashawn Newman, and I work for the Florida Department of Transportation Turnpike Enterprise.
Okay, and what is your role or your assignment currently?
I am the account research manager. I oversee the department that does extensive research into accounts, as well as we fulfill public records requests.
Okay, and prior to your position as an account research manager, what was your position?
Financial investigator.
And what were your duties as a financial investigator?
A large portion of that position was fulfilling public records for law enforcement as well as for our legal department.
Okay, and in this particular case, back on or about October of 2018, did you receive a subpoena, not you specifically, but the corporation, receive a subpoena regarding video surveillance from October 26th of 2018?
Yes, they did.
And in the form of legal service, correct?
Correct.
Either subpoena or public records?
Yes, ma'am.
And did you fulfill that request?
Yes, I did.
And are video surveillance kept in the normal course of business by your department?
Yes, they are.
And are they essentially made at or near the time of the event, here specifically October 26th of 2018, and routinely kept?
Yes, ma'am.
Your Honor, at this time, I will be showing defense counsel to mark this case probable F for identification purposes. May I approach the witness?
Yes.
And Ms. Newman, did you have an opportunity prior to your testimony to review the USB?
Yes, I did.
And what is it?
It's USB with various videos of the toll roads on the express lanes.
From October 26th of 2018?
Yes, ma'am.
Is it in the same or substantially the same condition as when you last reviewed it?
Yes, it is.
Any alterations or deletions that you can see?
No, ma'am.
Your Honor, at this time, the state reviewed this evidence states quadruple F, that states 81.
Is there any objection?
No, sir.
Thank you. It'll be admitted.
States quadruple F, A mark states 81.
No request to publish at this time, Your Honor. No further questions.
All right, my stellar legal panel for today are back with me to discuss that. Criminal defense attorney Jeffrey Wolf and entertainment attorney Mitra Ahurian. Mitra, I'm going to start with you this time. What was the importance of that testimony?
Yes, Judge. Counsel, all ready to proceed?
Yes, Your Honor.
Yes.
I think there's one thing that we can address outside of the presence of the jury. The state would like to revisit the identification of the decedent, specifically Christopher Thomas. Your Honor had previously ruled that we could not, without proffering to you what we've done.
What? I'm sorry.
If you recall the arguments previously when the defense cited the case law, Your Honor was asking us what efforts we've made to utilize a non-family member for purposes of identification of decedents. So we have at this point subpoenaed multiple witnesses, including, for instance, Travion Glass, who's refused to come to testify. We've also subpoenaed Patrick Deloach, who has had unsuccessful service on. We've subpoenaed Frito Bang, whose legal name is Frederick Gibbons. He has refused to comply with subpoenas, and his attorney, Zanita Davis, who had previously accepted service on his behalf, has now no longer accepted service on his behalf, so we're unable to bring him in. And there was an additional witness who we have not been able to serve, Jacoby Mills, we have not been able to serve. At this point, the state's re-arguing and requesting that the court allow us to use the family members as the only credible witnesses that the state has to identify the decedents. Today, specifically, we could call Leandra Phillips, one for the purpose of identification, but also for other testimony. That's relevant to the case.
Thank you.
Your Honor, we find it to be disingenuous to make the argument that witnesses that the state has been unable to contact for the last 3 years, and they know they have, to say, but we really have been trying while we've been in trial, as though those 4 people who they know to be unavailable are the people that comprise the universe of people that can identify the 2 decedents. That's clearly not the case. For there to be a good effort, a good faith effort to identify somebody who's not family member, they should maybe broaden their search to somebody that the family might know, maybe a very distant relative, something of that nature, as opposed to the 4 witnesses that they know that they have been unable to reach for 3 to 4 years. To now come and say, we're really still trying to reach them, Judge, is not passing the hurdle of good faith effort to find somebody other than a family member to testify. That is assuming that these are the only 4 people they know. And they already know that they can't find these people because they haven't been able to find them for 4 years. So to now come and say, we still can't find them, but we really have tried for the last 2 weeks, is not moving the ball an inch.
In addition to that, Your Honor,
yes.
In addition to that, Trevon Glass is scheduled for a deposition tomorrow. The state informed us just recently, during the lunch break, that they anticipate he'll be here for deposition. So it's a little immature for them to bring up premature. I'm immature. To bring that up now.
Counsel, have you discussed with your witnesses the possibility of identifying their family members?
Yes, Judge. In fact, that was the reason we sought out Travion Glass after obtaining a new address. We specifically told him that we would only be calling him for the purpose of victim identification. He said even that he would not be willing to come and testify due to safety concerns. If Your Honor also recalls Ms. Bradley, when Felicia Holmes was on the stand, she indicated that although she had met the decedents, that she was unable to identify them and unwilling to do so. The case law doesn't require the state to search the universe to be able to make an identification. We're proffering to the court that based on the discovery, based on our review of the case, we have no other credible witnesses that can identify the decedents.
My question, though, is, and maybe I wasn't clear enough with my question. Have you talked to family members about when they, assuming they testify and they are able to identify their loved ones, that it's concerning about what type of emotion they show and reflect, and we're looking really for more like an analytical, not some type of emotional response?
Absolutely, Your Honor. We spoke with Ms. Phillips previously when we had first addressed this. I will remind her. In fact, Ms. Bradley proffered to the court that what we would do to minimize any sort of emotional response from the family members is that we would not even show them the photographs while they were on the stand. The photographs are actually already in evidence, so what I can do is just, having already previously shown her outside the presence of the jury, I would ask her to identify the ME number associated with that photograph. And identify her son. And just for today's purposes, we would be only using Ms. YNW Phillips.
Judge, number one, the rule was invoked. They never brought that to the court's attention to get permission to allow any witness to remain in the courtroom. If the court recalls, at the very beginning of this trial, we discussed Jamie King, the mother of our client. And the state said they were not going to call her and had no objection. But we brought it to the court's attention immediately because we wanted permission of the court because she was listed as a state witness at one period of time. Now, I know they weren't going to call her because they gave us a Brady motion response indicating that she was under a criminal investigation, which would indicate that she would invoke her Fifth Amendment privilege concerning this matter, or any matter. But we did bring it to the court's attention because of the rule, and now to hear that a witness has been sitting in this trial from day one, apparently.
You think that's going to create the witness to fashion her testimony
I don't
in
know,
such a way?
I don't know. I'm not.
Took her deposition, I think.
Yes, we did take her deposition, but not on legal ID. And nothing, I don't know what else they're going to profit.
Judge, in her deposition, she identifies one of the decedents as her son. Further, Judge, as Your Honor is aware, Marcy's law allows the next of kin to remain in the courtroom during the proceedings.
Thank you.
Yes. Can I just...
I'm not trying to belabor this, but certainly I've not heard any inquiry from the state to the mother or the parents or any close relative if they know of any of his friends or any distant relative.
My experience suggests that more than half the times that this issue comes up, that there's a stipulation. I understand the defendant doesn't have to stipulate the identity of the alleged victims, but typically it's done by some agreement or to stipulate to it. It wasn't done in this case, that's fine. You raised it earlier, and I said, that's fine. See if you can go get somebody else. Counsel explained to me they made a good faith effort to get somebody else to be able to testify. That hasn't happened yet. There's a lull in the proceedings, and they want to move on and cross that T, dot the I, and have the alleged victims identified.
All right. I also want the case to move along, but quite candidly, they have not even inquired from the family about any distant relative, or I've not heard any proffer from them, or any friends of his that could come in.
I just heard her indicate 3 or 4 people that she...
Those were all state witnesses that they have not been able to locate for 4 or 5 since the inception of this case. They've all been implicated And I would suggest to you that one of the problems they have is that they could be charged with a crime. I don't represent them. I don't profess to represent them. I have not met them. But the witnesses that they have spoken about are all individuals that were at the studio or in one of the cars.
What's your concern about a family member identifying a victim?
Well, I think the case law is clear. That's frowned upon because of the potential problem.
And what's the potential problem?
The emotional problem that would cause a mistrial. And we've now been in this.
Didn't counsel didn't I just indicate or ask the counsel to advise me if they've spoken with the family member who's going to identify, and they've indicated and they're going to do to whatever they can to minimize it. They're not even going to publish the picture at the same time, is the way I understood it.
Well,
right? So
yes.
I'm passing the counsel respectfully. I understand your objection. I asked the state to see what they can do to get a different witness in. Apparent to me that they've tried, they're unsuccessful in that area. You think greater efforts need to be done, but we'll let the family member again is going to identify or indicate to the family that they're not to have any outburst of emotion or anything like that. And just we're going to move forward.
Understand you. The other component of the emotional and sympathy factor of a relative testifying is the juror hearing the voice and seeing the family member and thinking and developing a sympathy and maybe feeling like they owe them. So there's, even if they don't become emotional, the risk of that happening does exist.
When they show autopsy photos and everything else, there's all types of, and the juries are explained to try to, you got to separate the emotion from it. It's part of the jury instruction that we give them at the later time.
Just note,
serious case, and it's certain pictures and certain things are emotional. The jurors are explained that in the instruction that they're not to let emotions play a role.
We understand the court's ruling, note our objection, and we certainly don't want to stand up and object of this testimony in front of the jury, because I think that draws more attention. So if the court will allow us to have an objection to this.
Do you have any objection to it? Standing objection?
No, Your Honor.
Just for the record, Your Honor, they might as well say they looked for Jimmy Hoffa because they made no effort beyond what they already know, or they just came and voiced the name of people they haven't been able to find.
Like a tandem thing. I thought we talked about one attorney making the argument. It goes back and forth all the time.
I want to make sure we have a complete record.
Well, then talk to yourselves about it beforehand. But one attorney making the case, she's arguing for the state on this issue. One of you should be able to argue the issue, not have both of you come back and one after the next. All right? I've ruled.
Thank you, sir.
Let's bring the jury in. Ladies and gentlemen, thank you. Trust you had a nice lunch. Let the record reflect the presence of our jury, the defendant, the counsel, and the assistant state attorney.
Your Honor, we were going to call the witness. At this time, Leon Phillips.
Phillips, please. Ms. Phillips, welcome. Come on up here, please. When you get to that chair, what I'd like to do is remain standing. Raise your right hand and be sworn.
Do you solemnly swear or affirm the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Please state your full legal name for the record.
Leon Phillips.
Please spell your first and last name for the court reporter.
Leon, Leonbra, Phillips, Phillips.
Thank you.
Please have a seat. Ms. Phillips, that microphone will go up or down, but doesn't move back and forth. Okay. Counsel, you may proceed.
Thank you, Your Honor. Good afternoon, Ms. Phillips.
Hi, how are you?
Can you state your name, your full legal name for the jury?
Leon Phillips.
Okay. And are you related to one of the decedents in this case?
Yes, I am.
How so?
I'm his mother.
And who is that?
Christopher Thomas.
And you have previously been shown outside the presence of the jury a photograph with ME number 18-3119. And that was a head photograph. It's now in evidence under States 75. I believe it's photograph number 4. Who was that? Were you able to view that photograph?
That was my son.
If you recall, we showed it to you previously, the headshot with the medical examiner's number. Who was that in that photograph?
Christopher Thomas, my son.
Okay. And also,
Publishing States 7.
Positive 21915. Ms. Phillips, did you see who entered into the occupants who entered into that gray Jeep?
Mm-hmm.
And is that a yes?
Yes.
Do you recognize where your son entered that gray Jeep?
Yes.
Which seat, if you can identify for the jury?
He got in the back seat on the right-hand side.
Did you recognize the individual that got into the back seat on the left side, the rear driver's side?
Yes.
And who was that individual?
Jamell.
And Jamell, is that the defendant, Jamell Demons?
Yes, ma'am.
And do you know him by another name?
Melly.
And do you see Melly Jamell Demons in the courtroom?
Yes, I do.
And do you identify him by an article of clothing and where he's sitting in the courtroom?
He's sitting over there. He have a tuxedo. I think it was first.
Okay. Your Honor, let the record reflect the identification of the defendant by this witness.
The record shall so reflect the in-court identification of the defendant.
Nothing further.
Ms. Phillips, we want to express our condolences to you.
Thank you.
Thank you.
Nothing further to say.
Thank you. You can step down. Thank you, ma'am.
Time to say so to publish 61, state 60.
Judge, can we approach?
Ooh, I'm speechless, y'all. I'm speechless. Nah, defense can't say nothing, cause it make you look like a bad guy. You don't even want to. What you gonna say? The defense can't say anything. Like, that's not your son. That's the only reason she up there, and to identify that'll look bad. That'll play bad in the jury. I'm glad they didn't say anything. Let her get off the stand as fast as possible. She said he had on a tuxedo. She said he had on a tuxedo. I wonder who's next. Sometimes they get to flying through these witnesses. I mean, the state doesn't have that many more, I don't believe. I think they said they have a bunch of pictures. But I don't know who they going to bring to the stand and go through the pictures with. But I believe it's going to be some interesting testimony throughout the rest of the day. I'm trying to order me a new desk, because the desk I have right now is an L shape, and I have 3 monitors, so I can see 2 of them. But the third one, I always got to look over here to the other side. So I don't like the shape of desk I have, and I think I played it out. Hey, boo-boo. Oh, yeah, definitely. Yeah, Danae, that's what? I don't know how the mothers is sitting. But you never know. This still, it ain't over.
Published from state's table.
Yes, Counsel.
He get found not guilty. I don't know how that's going to play out. Or if he gets found guilty, you know he's going to have to, they give him opportunity to try to say something to prepare himself for.
Sorry, 1 moment. Go ahead, approach.
Oh, we back to quiet time. I don't know. I give all the props to the jury though, cause it had to be so hard not to fall asleep. But they get a lot of chances. I'll be taking little quick cat naps in the back, cause you can't talk about the case.
Publishing photograph 1. Photograph 2. Publishing video 1.
Didn't do that. Ben not even started saying you did.
Publishing video 2. Video 3. Publishing now video 4. Publishing video 5. Publishing video 6.
Like, get right there, like, you know you come back.
Publishing video 7.
All that extra shit, like, they leave the most important shit here.
Publishing video 8.
Right there.
Publishing video 9.
This bitch look like he got 5 kids at the student pickup right now, waiting.
Publishing video 10. Publishing video 11. Publishing 12. Publishing 13. Publishing video 14. Publishing photograph. Another photograph. Third photograph in that series. Fourth photograph. Fifth photograph. Sixth photograph. Seventh photograph. Eighth photograph. Ninth photograph. 10th photograph.
12 photographs. That's the end of State 61.
Just publishing now from State 64, the previously shown photographs to Defense Counsel. Photo 1. Oh, I'm sorry. State 64. Photograph 2. Photograph 3. Photograph 4. Photograph 5. Six. I'm sorry, 6. 7. 8. 9. 10. 11. 12. 13. 'Use the other computer. It works a little bit better with your just a momentary delay.
52. 43. 44. 45. 46. 47. 48. 49. 50. 51. 52. 53. 54. 55. 56. 57. 58. 59. 60. 61. 62. 63. 64. 65. 66. 67. 68. 69. 7. 148. 149. 150. 151. 152. 153. 154. 155. 156. 157. 158. 159. 160. 161. 162. 163. 164. 165. 166. 167. 168. 169. 170. 171. 172. 173. 174. 175. 176. 180, 181, 182, 183, 184, 185, 186, 187, 188, 189, 190, 191, 192, 193, 194, 195, 196, 197, 198, 199, 200,
Somebody make it stop.
201, 202, 203, 205, 36,
I know she driving everybody crazy at this point, and I'm sick of it. I really am. What's wrong with her? No, like for real. 1,000 pictures? We really need 1,000 pictures. 1,000. Like, oh my God.
211, 212, 213, 214, 215,
Council, I'll hold it there for a second. Sure. Thank you. Let the record reflect. I was just passing notes that one of our jurors needs a restroom break, so we'll take a short recess. Ladies and gentlemen, remember the admonition: do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case. No research. Thank you. Your notepads on your chair. Thank you. Let the record reflect the jury stepped out. Councilor Manuel and defendants damaging your restroom break. All right, can you arrange that phone, please? We're in recess. Thank you.
Why it was important, because once that, because the defense is going to continue to say that's not his phone. They're going to keep saying that. I think after 5 billion pictures, it's going to be hard to refute that is his, to disprove that that's his phone. Even if you try to go that route as a defense counsel, to me, it's going to make you look foolish. So it's kind of going to be a waste of time to keep doing that. They're better off focused on the expert witnesses and, refuting some of that testimony, showing errors. But to try to say this isn't his phone, it's going to make other parts of your case look bad. You know what I mean? Because it's like you fighting an uphill battle. Sometimes you just have to concede some of this stuff. However, there's a lot of stuff in that phone that's damaging, and I think they're going to be bringing back cell phone people, for lack of a better term. So once they bring back the cell phone analysis people, and they've established firmly, which I think they have at this point, that that's his phone, again, they're going to show that at the time of the incident, phone was at A. Shortly after the incident, the phone went the opposite way of, I guess, the hospital. If I'm right, if I'm wrong, please let me know. But if that's the case, then he's going to be tied to this phone. They're going to use that to further show that things did not play out that night as he said they did. So that's where we're at. It was crazy, though, watching all those people he FaceTimed. So I bet that part was kind of fun. Lil Uzi. Who else we saw in there? Kodak. Who else, y'all? I saw a couple people in there. A few of his girl.
Hello again from our Law and Crime studios here in New York. Our coverage continues in Broward County, Florida for the trial of rapper YNW Melly. While court is on a brief recess, I want us to recap some important testimony of Sergeant Christopher Williams. He was the only witness of the day yesterday, and his testimony continued for just a bit this morning. Sergeant Williams is a shooting reconstruction expert and was a witness for the state. So let's hear what he had to say under his direct examination.
So in terms of the distance between the individual in the rear driver's side seat and Mr. Thomas in that, do you know there to be a minimum distance they were separated by?
Can you restate that?
Sure. The individual, whoever was in the rear passenger seat on the driver's side, and then Chris Thomas, who is in the rear passenger seat passenger side. Is there a minimum distance that they are separated by?
There is.
And how do you know that?
So we have a known distance. As I said earlier, we are confined to the inside of this vehicle. So we have a known distance of shoulder width inside the back seat of this vehicle. We know a distance of shoulder width of Mr. Thomas, and then we would be able to deduce the difference between the center console and another passenger.
So in terms of the photos at the Jeep when it first came to the hospital, are you aware of how the back center console was positioned?
Yeah, it was down just like that.
And showing from what's been previously admitted into evidence as States 30, photo DSC_0127. Is that important for your reconstruction?
Correct. So this is the blood that is on the center console is consistent with Mr. Thomas crumbling into the position above or onto the center console of the back seat. So this is a demonstrative photograph to show that you can fire a firearm from that position in the direction of a passenger who would be seated in that seat.
Okay. Now, looking from the other angle, what are you looking at in this photo, which for the record is 6717?
And that is just a forward picture from the front of the vehicle facing towards the back of the vehicle to show that it is still possible to fire a firearm inside the vehicle.
Okay. And then in terms of the measurement, how far away is the firearm from the face at that demonstrative photo, which is 6719?
In this particular demonstrative, it's approximately 6 inches.
Can you tell the ladies and gentlemen of the jury if Mr. Thomas was sitting straight up and didn't move to the side to get away from a gun?
At one point, I believe that he did.
And how do you know that?
Because Mr. Thomas has what's called a defensive wound on his right hand, and that defensive wound was caused by a projectile. So I believe that at some point he turned and put his hands up or attempted to de-escalate what was going on and received the firearm projectile through his thumb.
Okay, and so you're pointing to your right hand. In terms of the injuries to Mr. Thomas, do you recall which hand they are on?
I would have to look at the photograph.
Okay, and we can come back to that in a moment on that. So the, and Ms. Smith is looking to get the any photos. The defensive wound. Why is that important for you as a shooting reconstructionist?
Because it lets me know that Mr. Thomas was not aware of what was going on. He was taken by surprise, and his hands being up. If his hands were down, he would not receive a projectile through his thumb. His hands are in an up position, almost saying, maybe don't shoot, or I relinquish or something, but he receives a defensive wound due to that projectile. And I think at that point he repositioned to be forward facing.
Were there any defensive wounds on Anthony Williams?
No.
So there is testimony that there was a driver in a car. Could the driver, Portland Henry, have gotten that angular shot on Anthony Williams?
No.
Why not?
He would have to have a rather large arm. Like, he'd have to be Inspector Gadget.
So in terms of, did you measure the height of Mr. Henry?
Yes.
And what was that height? If you need to refer to your report, please let me know.
He's 70.5 inches tall.
Okay. And in terms of his arm length, did you measure that?
No, I did not.
No. In terms of the height to his shoulder, did you measure that?
No.
So with regards to the length of his arm, why do you say he would have to have Inspector Gadget length arm to get that shot on Anthony Williams?
Because you would have to, it would be a very awkward position that his wrist is, no human wrist is simply capable of being in order to reach around, extend it out, and pull the trigger.
Okay. In terms of the intervening objects, how does that help you in saying where that firearm had to have been?
The firearm had to have been, would be due to due to the headliner being there, the head rest being there, that all puts it all in line with the backseat driver passenger.
Okay. In terms of the angle for the driver to get the shot on Christopher Thomas, is that possible?
No.
Why not?
Because the injury to Christopher Thomas's cheek is an exact circle. And if Cortland Henry is pointing back from the driver's seat to the direction of the position of Christopher Thomas, you would expect to see a leading edge injury to his cheek instead of a perfectly circle on his cheek. On top of it, you would see more blood on the seat that Cortland Henry was sitting in for both. If he were to make both shots of those two individuals, there would be a substantial amount of blood on his seat.
Now, speaking about the rear passenger, can you tell the ladies and gentlemen of the jury or identify who was in that seat?
The rear passenger?
Yes.
Driver's side?
Yes.
I was advised that it was...
Objection, hearsay.
So, without going into that, in terms of what you were advised, can you say, based on your own personal knowledge, who was sitting in that seat at the time of this homicide?
That would be Mr. Demens.
Okay. And how can you say that?
Can we approach? Sure.
So, Mr. Williams was not even aware he was about to be shot. When Mr. Williams was shot, Mr. Thomas puts up his hands and is shot, and then is shot again. Okay. There's no time for anybody to switch a firearm. If there were, I believe one of those individuals would be alive. There's no time to switch. It was a very, a rather rapid event of firing.
Okay. Can you say the length of time between the fatal shots and then the staged drive-by shots later on?
It was enough time for the heart.
It's 66 degrees in here, and it's 13 of 3. I just wanted to report that to the court because I'm ready to borrow the jacket of one of these nice BSO officers.
You all set? Ready to go?
Yes, sir.
How about state? Can you see if the jury's ready?
That's good.
Feels colder than 66.
That's what Gary said.
Keep dropping.
Jury ready?
Yes, sir.
All right, agreement. Jury entering. Gentlemen, thank you. Please be seated. Let the record once again reflect the presence of our defendant, the counsel, the assistant state attorney, ladies and gentlemen of the jury. Ladies and gentlemen, I think the statements in the midst of this publication of certain photographs. What exhibit number is this again, counsel?
64, the extraction of the 98 of 7th.
Thank you. You ready? You may proceed.
276. 279. 280. 281. 282. 283. 284. 285. 286. 287. 288. 289. 290. 291. 292. 293. 294. 295. 296. 297. 298. 299. 299. 300. 301. 302. 303. 304. 305. 306.
Right now, we're prosecuting.
339.
For my people watching on Twitch, make sure you guys subscribe. I greatly appreciate it.
340.
Okay.
341. 342. 343. 324. 345. 346. 346. 347. 348. 349. 350. 351. 352. 353. 354. 355. 356. 357. 358. 360. 359. 361. 362. 363. 364. 365. 366. 367. 368. 369. 370. 371. 372. 373. 374. 375. 376. 377. 378. 379. 380. $381. $382. $383. $384. $385. $386. $387. $388. $389. $390. $391. $392. $393. $394. $395. $396. $397. $398. $399. $400. $401. $402. $403. $404. $405. $406. $407. $408. $409. $410. $411. $412. $413. $414. $415. $416. 421. 422. 423. 424. 425. 426. 427. 428. 429. 430. 431. 432. 433. 434. 435. 436. 437. 438. 439. 440. 441. 442. 443. 444. 445. 446. 447. 448. 449. 450. 451. 452. 453. 454. 455. 456. 457.
473. 464. 465. 466. 467. 468. 469. 470. 471. 472. 473. 474. 475. 476. 477. 478. 479. 480. 41. 42. 43. 44. 35. 36. 47. 48. 9. 190. 181. 182. 183. 184. 185. 186.
503. 504. 506. 507. 508. 509. 510. 511. 512. 513. 514. 515. 516. 17. 518. 519. 520. 521. 522. 523. 524. 525. 526. 527. 528. 529. That would conclude the replication of the spreadsheet photos from 772, 713, and 807 calls.
Thank you.
Karen, your consulting schedule?
Sure. Maybe we should take a break. Need a break? Fine. Please. Why don't you come side first?
That was a tremendous leap of faith. It was too attenuated, and the jury
Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. And certainly no research. Also, ladies and gentlemen, just remember that next week is the 4th of July week, and The courthouse is closed one of the days, but we had indicated because of issues with witnesses that we were going to break and wouldn't return until the 10th. So July 10th is the next scheduled date we're going to be in. We're not going to be in session next week. All right, so we'll see you all back on, that's July 10th, that's Monday at 9 a.m. All right? Thank you, ladies and gentlemen. Have a nice morning. You can open these on your chairs.
Obviously, they can have a recap.
Thank you. Let the record reflect the jury step down. Counsel remain along with the defendant. So you said there's more that you have to publish to the jury?
Yes, there's all the videos on the main 807 phone. The defense counsel needs to go over and I have to show them exactly which ones, and we have to go through those, and then we'll have to read.
How long are the videos?
There's tons of them, Your Honor. I have to prove it's the defendant's phone.
Y'all make it make sense. Good.
So, how are we going to handle this? You want to, have you seen the videos? I take it, I mean, you have them, they're set over discovery, correct?
Yes. Well, they're now isolating those that they intend to, and we'll make sure that we do what we need to do during the time limit. I don't think we need the court's intervention.
Well, this is my thought. If there's an issue about it, I don't want to have a problem with it. My thought is, if there is an issue about it, we'll resolve it and we'll do it on some date next week when we're off. We'll just pick a date that everybody's good for, and we'll resolve it during that week if there's a problem.
Makes good sense to me, sir.
What time do we have Friday? Have Friday issues? Any issues Friday? I know we have hearings.
In terms of the 6th, I believe I scheduled the depot for their defense witness.
I wanted to ask you about that too, but let me hold on. I just want to find out, make sure that we need time on that Friday. That is the 14th, I guess.
The 7th, Your Honor.
Next week, Friday.
Yeah, the 7th.
It's the 7th. I apologize. I'm living on the week of the 10th. You're right.
7th is the fine for the statement.
So could we clarify, because we were supposed to get a date today for the deposition, and now she's saying she's scheduled the 6th?
No, we're talking about the 7th.
We're going to get the depositions at the 7th.
Okay.
So, counsel, on the 7th, everybody's available on the 7th if we need it? So how much time do you think you need?
I have a 1 o'clock afternoon in the afternoon of the 7th in federal court. So something in the morning, and also I would need to be here if everybody else is.
So, how much time do you think you need?
I don't know if we'll even need anything, or if we're fine on that, so.
So why don't we just plan on, if you need it, we'll do it at 11 o'clock?
Sure.
That'll give you an hour. Is that all right? Does that work for you?
Yes, sir.
All right, so we'll do it at 11. That's good for everybody, yes?
Yes, sir, that's right.
All right, on the 7th, and what I'm going to ask you to do is contact my office beforehand and just tell me, if you need the time or you don't need the time, all right?
Thank you very much.
Yes.
Now, what about the depositions? First, yesterday, I think, when Ms. Smith indicated to me there was a witness that stated, or I guess you did, Ms. Bradley, objected to the scheduling of the deposition without your knowledge and consultation beforehand. And Ms. Smith indicated she didn't believe the witness was going to show anyway because you would have been trying to get the witness to come. And he didn't. Is that deposition, what's the witness's name?
Fabian Glass, Your Honor.
And that witness looks like it's going forward, the deposition?
His sister called our office to ask if it was Zoom or if it was in person, and she was told that it is in person.
All right, so assuming this witness's deposition is taken, when is it set for?
Tomorrow morning, Your Honor. So Judge Siegel has been kind enough to move my hearings around. So for that, for Mr. Smith's case, so I should be available.
So everything's good?
Yes.
All right. Was there another deposition?
Yes, Judge. She had stated that she's having our witness depose on...
Who was your witness again?
That would be Larry Daniel. Thank you.
Yes. I was told yesterday to pick a date and they would make him available.
That's the cell phone witness?
Correct. And so the first date I'm available next week is Thursday the 6th.
They're good?
I will check with him, but this is the one that she wants him in person, and per the rules, 92.142, she needs to be providing his airplane ticket and his hotel.
Well, the court reporter is going to appear via Zoom, so I'll do it via Zoom on that. That's not a problem.
Okay, thank you. I'll speak with Larry, make sure he's clear, but I did tell him yesterday that it would be next week, so I'll confirm that and I'll let her know this evening. But it shouldn't be a problem.
And Your Honor, I filed a motion to compel any of the materials for Mr. Daniel that he has done. Nothing's been provided other than a CD. So if he's relying on any demonstratives, anything else like that, that would need to be provided to the state forthwith.
Did you give a report or anything?
We did not give a report. We were fine with the FBI, and again, I had reminded the court she had given me case law last week, which now requires me to bring my expert. He is doing tests. If I get a report or any of the results back from the testing of these tools that he's using, I will definitely give it to her prior to him coming. I'll give it to her upon me receiving it.
My question was, do you know if he has a report as of yet?
Nothing as of yet, Judge.
So I'm hearing something about testing being done and things of that nature. So if anything is going to be done, it needs to be done and turned over, I would say, prior to the deposition, because they can't ask about something that hasn't happened.
I agree with you. Like you said, the minute I have something, if something is prepared, I will provide it for him.
Well, I guess the concern Bradley has is that if there's not a report turned over to her, and when she's walking into the deposition the first time that's handed to her, she's at a loss of a disadvantage is what I think she's trying to convey to me.
I promise I will not ambush the state, Judge. So as soon as I have something, if there's something created, I will give it to her within minutes of me receiving it. There's nothing else I can do about it. She wants to compile something that doesn't exist at this point.
So, Your Honor, my concern is it sounds like the expert was going to do some sort of testing once he gets here. That was how I took Ms. Liberty's last statement. So in that instance, what's the purpose of doing a deposition? If he's going to be creating new information or new reports as he's testifying. So I guess that's...
I don't know that that's what the intent was. I thought that was a generic statement as to what the witness may be. I don't know. There's no report now. You want to take his deposition. Obviously, if there's some, he makes a report or does some testing and it's not turned over to you, you don't know about it, and he's not explaining anything in the deposition, and you want a new report, new evidence, that's the Richardson violation. We're saying there's a discovery violation. We talk about it, and you have a right, I would think, to cure whatever problem there is and redepose the witness, or if that happens, we'll make some accommodation. I mean, I would think that'd be appropriate.
I agree, Judge.
So let's take it one step at a time. Counsel suggests that she's going to turn over whatever she has as soon as she gets it, and I accept her representation. She also, Ms. Liberty also indicated that she was going to reach out to the witness, correct? You said you find out whether something's forthcoming. So we'll take that one step at a time, but I understand your concern. You don't want to be ambushed or sandbagged with a report and start asking questions and you haven't seen the report yet. So let me know.
And so the other concern then becomes a potential Daubert issue. If he's doing some new testing or something like that, so that would have to be raised. If it's not been provided, I can't file a timely Daubert objection if I don't have the information. So just want to make sure that's clear for the record, Your Honor, is aware of that issue as well.
we must cross the bridges as they approach.
I don't know what the issue is with the witness. You're saying the witness was never disclosed?
No, Your Honor, what happened was the witness was listed in, oh goodness, 2022. And if I'll pull up the email so I'm quoting exactly, I had his deposition scheduled for March of
Just to move them on, we were not going to call him because the FBI.
So you had him on the list, counsel scheduled for deposition, then you withdrew him as a witness?
Yes.
This is that witness, all right.
Okay, and then last week she gave us a case from Wisconsin on the Fitbit and a lay person. So I started researching the Fitbit and all the case law that goes with it. So at that point, based on her providing this case law that she's relying on, I now have to get the expert to test the Fitbit and the health app on the iPhone. So once I have those done, because she's going to go back to that motion, the state will talk about the motion to come. I will guarantee the minute I have some type of proof, if he gives it to us, it will be provided to her. But that is the issue. She told us last week this is what she's relying on, and we have to prepare for it.
So in terms of, he's no longer a cell tower expert as previously listed. So that's what I was prepared to depose him on, was he was listed as a cell tower expert, and he was deleted as such in...
And now we're trying to list him as a Fitbit expert?
Well, she's going to, based on the case law she provided last week, yes, Judge.
So on Monday, March 20, 2022, Ms. Liberty emailed myself, Mr. Adelstein, Mr. Howard, and Mr. Haddad, saying we will not be using Larry Daniels for the cell towers. We will remove him from our witness list. Thus, there is no need for the depositions tomorrow.
Well, counsel suggested she did that. She said she withdrew as a witness.
Correct. So just so that it's clear on the record as to why the deposition wasn't done prior to the start of trial. So she has not yet listed him as an expert in new areas on that. So that would not be a Richardson violation in terms of that. So I would just ask if there can be some sort of proper as to exactly what he's testing or what he's doing on this particular item so that I could actually be prepared as opposed to going and thinking I'm doing a cell tower deposition next week.
So it's not about cell towers, correct? It's about Fitbit.
Yes, based upon Ms. Bradley's, the state attorney providing me certain case law is very specific to what she provided me. So he's going here and saying he's not sure what we're, making it very clear. That case is what we need an expert for.
I'm not familiar with the case, but let's take the case aside. This expert you have is in response. You're saying you're listing a new witness. You're listing him again only as an expert this time as to Fitbit.
Well, we'll use the word celebrate because she's going to get the health data off of the celebrate download. So we'll just call her a celebrate expert. Like exactly cover everything, and she knows exactly what she's preparing for to celebrate. And he is a certified celebrate expert, and that is on his CV that was provided for us. So that should be no surprise.
I guess you don't have a report yet.
There is no report in existence, as I said.
You don't know if you're getting one.
Exactly.
And so counsel's asking for a proffer as to what you believe this witness is going to testify to.
Celebrate.
Anything more than that?
No, it will be celebrated.
And when you say celebrate, what do you mean celebrate?
So we just set 2 hours of her data. That's all from Celebrate. So what she's going to try to.
Well, what's his opinion going to be? Maybe that's the better way to do it.
So his opinion will be on the reliability of the health data app that's on the iPhone X, which is the model of phone. I believe she's done that data down the line.
So that's what he's going to share opinion on. That's what you retain him to do, render an opinion in this area.
Exactly, Judge, yes.
Okay. So that gives you a little bit of heads up.
Okay, thank you.
And we'll see where it goes, and we'll take it one step at a time.
Okay, thanks, Judge.
Anything else to discuss?
Yes.
Mayor, have a wonderful Fourth.
Happy Fourth.
Oh, by the way, thank you, but this motion, you filed this motion about a jury view? Is that right?
Yes, Your Honor. So I was trying to see if we could take defense counsel down to look at the vehicle, but it's my understanding they've put it back into storage.
It's not there anymore?
Nope, that was what Sergeant Colliard with the Broward Sheriff's Office Crime Lab told me when I asked about that on a break.
So is this jury view item moot now? Not going forward with it?
Well, not for today at this
For
point.
any day?
So no, we could do this on another date when we return.
So the date I gave you for the hearing, just plan on being there. We'll argue whatever motions there are. If this motion's pending, we'll argue the motion.
Yes,
all right. Regarding the jury view on that Friday, so okay.
Maybe we can take a look at the vehicle sometime next week.
Good. Good with everybody?
Yes, sir.
All right.
Alrighty then. I really don't know if I should just let it run so y'all could, didn't much really happen today other than the state introducing these pictures and so forth into the evidence. It really was the most boring day, I think, of the whole damn trial. Am I wrong? We got to watch 20 minutes of freeway footage. But this is all to set up something down the line. But again, if you're here just to watch the trial, we will be back on the 10th with the trial. But stay tuned in between then. Make sure y'all hit the notifications bell because we will be having other stuff going on. Make sure you guys join the Discord. The link is in the description so that way you can join in on conversations and future shows that we got going on. And thanks for the super chat donations. I really greatly appreciate it. It allows me to continue doing this and upgrade equipment and so forth. So again, I appreciate all you guys. I'll see y'all next time. Y'all know the slogan, one love or no love. If nobody told you they love you today, I love you, and I'll see y'all next time. Y'all know what it is.